60 seconds until we're ready to go. Thirty seconds. Ten seconds. At 6:01, you can take it away.
Good evening. My name is Joni Hiramoto, and I will be presiding over tonight's mock trial. Would the bailiff please call the court to order?
Superior Court of the State of California, County of Contra Costa, Department number 39 of Zoom is now in session. The Honorable Judge Hiramoto is now presiding. Please come to order. At this time, please turn off your camera and mute your microphone unless you are presenting. The next case is People v. Cobey.
Thank you. I would like to welcome the students, their coaches, and supporters, parents, and anyone else who was watching this evening's round. Through my years of association with mock trial, I have found it to be one of the most important activities that a student can participate in during high school. Not necessarily because it gives you an excellent introduction into courtroom procedure and how our justice system works, although it does do that. But more importantly, because it trains students to think, to analyze, to speak, to learn the skills of rhetoric and persuasion. And these types of skills will be useful to them no matter what career they decide to pursue, whether it is within the judicial system or whether it is in any profession or occupation. The skills will be useful to them and will serve them well throughout the rest of their lives. Thank you all for your participation and for your hard work in this extraordinary activity. To help myself and the attorney scores, I would like to ask the prosecution team to state your name and roles.
Good evening, Your Honor. My name is Michelle Giovinazzo, and I represent the people of California in this matter. Tonight, I will be delivering the pretrial argument. May our trial attorneys now introduce themselves?
Yes.
Good evening, Your Honor. My name is Vivian Arndt, and I represent the people in this matter. Tonight, I will be conducting the direct examinations of Deputy Sheriff Garrett and Dr. Dunn, and the cross-examinations of Dr. Clay and Francis Yazzie. In addition, I will be delivering the opening statement.
Good evening, Your Honor. My name is Jessica Milmo, and I represent the people in this matter. Tonight, I will be conducting the direct examinations of Angel Russell and Terry Edwards.
Good evening, Your Honor. My name is Elsa Cook, and I represent the people in this matter. Tonight, I will be conducting the cross-examinations of Danny Emling and Jamie Cobey. In addition, I will be delivering the closing argument. At this time, may our witnesses now introduce themselves, Your Honor?
Yes, please.
Good evening, Your Honor. My name is Aaron Zemmelman, and I am Deputy Tony Garrett.
Good evening, Your Honor. My name is Annika Swan, and I am Angel Russell.
Good evening, Your Honor. My name is Nadia Majedity, and I am Dr. Charlie Dunn.
Good evening, Your Honor. My name is Kakomi Banerjee, and I am Terry Edwards. May our courtroom staff now introduce themselves, Your Honor?
Yes, please.
Good evening, Your Honor. My name is Theo Kushner, and I'm the courtroom clerk. Time signals will be visual and audible at 2 minutes, 1 minute, 30 seconds, and stop.
Thank you. Are there any more members of the prosecution team?
No, Your Honor.
Okay, thank you very much. At this time, I would like to ask the defense team to state your names and roles.
Good evening, Your Honor. I am Daniela Kuthi Cervantes, KU-THY-CERVANTES, representing Jamie Cobey in this case. Tonight, I'll be arguing the pretrial motion for the defense. At this time, may our trial attorneys please introduce themselves?
Yes, please proceed.
Good evening, Your Honor. I am Hella Khalil, KHALIL, representing Jamie Cobey in this case. Today, I will be delivering the opening statement as well as conducting the direct examination of Dr. Tyler Clay and the cross-examination of Dr. Charlie Dunn.
Good evening, Your Honor. I am Avery Cross, CROSS, representing Jamie Cobey in this case. Today, I will be conducting the direct examination of Francis Yazzie and Danny Emling and the cross-examination of Angel Russell.
Good evening, Your Honor. I am Ami Baid, BAID, representing Jamie Cobey in this case. Today, I will be conducting the direct examination of Jamie Cobey, and the cross-examinations of Tony Garrett and Terry Edwards, and delivering the closing argument. At this time, may our witnesses please introduce themselves?
Yes, please proceed.
Good evening, Your Honor. I'm Simi Shetty, SHETTY, as defense witness Francis Yazzie.
Good evening, Your Honor. I am Carter So, SOE, as defense expert witness Dr. Tyler Clay.
Good evening, Your Honor. I am Jordan Vereen, BEREEN, as defense witness Danny Emling.
Good evening, Your Honor. I am Noelle Yamamoto, YAMAMOTO, as defendant Jamie Cobey. At this time, may our courtroom staff please introduce themselves?
Yes, please.
Good evening, Your Honor. I am Richard Prabhakar, PRABHAKAR, as the courtroom bailiff. My duties as bailiff will consist of swearing in all witnesses and keeping order in the court at all times.
Good evening, Your Honor. I am Arav Manjunath, MANJUNATH, as the shadow timer for tonight's trial. At this time, may our substitutes please introduce themselves?
Yes.
Good evening, Your Honor. I am Billy Piggott, PIGGOTT, substitute for the defense.
Good evening, Your Honor. I am Cindy Zhu, ZHU, substitute for the defense.
Good evening, Your Honor. I'm Apurva Khandelwal, KHANDELWAL, substituting for defense.
Good evening, Your Honor. I am Kaylin Huang, HOAD, substitute for the defense.
Good evening, Your Honor. I am Aiden Flynn, FLANK, substitute for the defense. This concludes the introductions for the defense.
Thank you very much. This is a bench trial. You must complete your presentations within the specified time limits. The clerk will signal you as your time for each section of the presentation begins to run out. When your total time for each section runs out, you will be stopped, even if you have not finished. Attorneys must call 4 witnesses within the time limit. At the end of the trial, I will render a verdict of guilty or not guilty in relation to the charges brought. The teams will be rated based on the quality of their presentation, independent of my verdict. Barring unforeseen circumstances, no recesses will be called. If for any reason a recess is necessary, team members should remain in their places and should have no contact with spectators or coaches. Remember that objections are limited to the California Mock Trial Simplified Rules of Evidence located in the case packet. If there are no questions, the pretrial arguments will begin. Both sides have 4 minutes to present their arguments. The defense will begin. I will interrupt to ask clarifying or challenging questions. Time spent answering my questions is not included in the 4-minute time limit. At the conclusion of your argument, Each side will be offered 2 minutes of rebuttal time. Remember that rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. Is counsel for the defense ready to begin?
Yes, Your Honor. May I proceed?
Please begin.
The Fourth Amendment guarantees each person a right against unreasonable searches and seizures of their houses, persons, and effects. Over the course of 200 days, however, my client Jamie Cobey was a victim of a lawless search administered by the Sheriff's Department. On October 10th, 2020, Deputy Sheriff Tony Garrett provided my client's landlord and neighbor, Eric Smith, with a motion-activated state-of-the-art camera that would record when motion within 125 feet was detected. The camera was placed on a 10-foot tall post on Mr. Smith's property and was pointed towards Ms. Cobey's backyard. The entirety of my client's fenced-in backyard was captured, with the camera being activated 24/7 all the way until April 29th, 2021, providing the Sheriff's Department with access to all of the footage through the cloud. Under Stipulation 25 on page 16 of the case materials, the placement and use of the camera are deemed state action. My client told Mr. Smith that he did not have permission to aim the camera at her backyard, but this statement was ignored. My client's rights to privacy of her home were violated. Thus, any information captured utilizing this improper process must be excluded from trial. For these reasons, the defense respectfully requests that a motion to exclude the image from the camera, Exhibit A, be granted. To begin, since the home is afforded heightened privacy protection under the Fourth Amendment, the backyard is entitled to similar heightened protection because it is curtilage. This alone makes the space protected, and thus any search would require a warrant.
So, counsel, what is the definition for curtilage, and how does the backyard in this case meet that definition?
Well, Your Honor, to see whether or not the area can be deemed curtilage, we can look towards the 1987 case of U.S. v. Dunn, which defines 4 areas that you can look at to determine whether or not an area qualifies as curtilage. And these 4 areas include the proximity of the area to the home, whether or not the area is included within an enclosure that also encloses the home, the nature of the use of the area, and the steps that the occupant took to protect the area from observation by passersby. And the way that the area in this case satisfies all those 4 requirements, starting with the proximity to the home, the backyard was adjacent to my client's home. It was right outside of their house, and it was very close in nature. So the proximity requirement is satisfied. Secondly, to the enclosure, the fence that surrounded the home also enclosed the backyard. It was a 6-foot tall wooden fence that surrounded the majority of the backyard. So in terms of enclosure, the enclosure was shared between the home and the backyard. Now,
So
for a matter,
isn't majority the key word there, because the 6-foot tall wooden fence did not enclose the entire backyard, correct?
it enclosed the grand majority with the exception of a 3-foot wide and 4-foot tall chain link gate.
Okay. Where was you said that the camera was able to take a picture anywhere inside this enclosed area?
Yes, Your Honor, the camera was able to capture everything in the backyard.
Okay. So what is it exactly that you're trying to suppress?
We are trying to suppress the image labeled Exhibit A. It is the image of the snake tongs captured by the camera.
And where were the snakes? Where was that image taken from? In the yard, where were the snake tongs located?
The snake tongs were located in the northwest corner of the yard.
What is the proximity of the area where the snake tongs were located to the 3x4 chain link gate?
Well, Your Honor, based on the information given to us in the case materials, someone who moved their body towards looking in through the gate would be able to see the tongs. So based on that, we would presume that the tongs were located relatively close to this gate.
Okay, but would a passerby be able to see the tongs without tipping their head over the chain link gate?
Well, Your Honor, based on the materials given, an individual would have to physically look in through the gate. They couldn't just walk past and see it. There would have to be an intrusion of the head in order to look through and see the tongs.
Thank you. Could you complete the analysis of curtilage? I think the next one was use of the area.
Yes, Your Honor. So for the qualification of use of the area, the use was quite domestic. If we compared it to the usage such as in the Dunn case where it was a narcotics laboratory, this use was more for gardening or other leisurely practices, or clearly storage, as my client was storing items in their backyard. So the use was a much more domestic use, and a use that we would associate commonly with how you would use your backyard or your home.
Right. And then
yes.
The fourth step?
The fourth one was the protection of the area from passersby. So the defense would argue that the presence of the 6-foot tall fence in itself would be a way to protect the grand majority, as mentioned, of the backyard from observation.
Okay. There was kind of this peekaboo thing, the gate, the chain link gate that was smaller than 6 foot tall. But you would have to physically cross it. You'd have to intrude the line of that gate in order to see the area where the tongs were. Is that right?
Yes, Your Honor, there would have to be an intrusion in order to see.
You did say that your client told Mr. Smith that your client objected to the camera being focused on the backyard, or he did not have permission to take pictures of that backyard area.
Yes, Your Honor, that is correct. My client told Mr. Smith that they did not have permission to angle the camera towards in the way that it was capturing the backyard.
But isn't it also correct that your client forgot about it? How does that indicate that your client subjectively cared about the privacy of this area?
Well, Your Honor, to determine whether or not there was a subjective expectation of privacy, a requirement is not the amount of steps that an individual may have taken. So taking futile steps to show that this expectation of privacy was truly there is not a requirement. My client did say that they didn't have permission, and Mr. Smith was their landlord. So my client felt that they didn't have as much ability to demand much from Mr. Smith. So constantly asking to take off the camera, it might not have even worked for my client. They said they had told him earlier, she had mentioned it earlier, and he just ignored it. So she really felt that she was out of options to continue asking and asking.
I see. Please continue.
Thank you, Your Honor. To compare a similar backyard to the one that we have in our case, we can look at the case of Ramon Bustamante, which in that case also had certain portions that were chain link or wire fences. However, there was an enclosure that enclosed the majority of that enclosed the backyard as well as the home, and also the area in that case was very close to the home, as is in the case at bar. Secondly,
right. Although that's different from this case where it's a photograph, right? So was that really an intrusion? Isn't this more like California versus Serralo, the 1986 case, where there was a plane that flew over and the court found that there was no violation of privacy because this is a non-intrusive photo. Anyone flying over using the public airspace is going to be able to look down. Doesn't that sort of take away from the expectation of privacy in this case?
Well, Your Honor, the intrusiveness of a search is not just the nature of the search itself. It is also the intensity of the search and the duration of the search, what would make it something that would be unreasonable to deem as not a violation of someone's privacy. So in the case of Serralo, yes, the camera flew over and took a snapshot, but that's all it took. It took a single snapshot of a single moment in time of a single area. However, in our case, the camera was capturing information for a span of around 200 days, which far exceeds any other period of surveillance in any of the cases provided. So the search in our case was much more intense, and the duration was much more severe than a case like California v. Cirolo, where the snapshot was of a singular moment at a singular point in time. It was not a 24-hour, intense, 200-day long surveillance as it was in our case.
Well, isn't your case also involving a single snapshot?
Well, Your Honor, although the single snapshot is what is being contested here or discussed here, what makes the search unconstitutional or not, a violation of the Fourth Amendment or not, is the nature of the search itself, the means through which this single snapshot was captured. Although it is a single snapshot, it was captured utilizing an unconstitutional surveillance of 200 days of an area of curtilage using a 24/7 motion activated camera placed on a 10-foot tall post.
Thank you. Please conclude.
Thank you, Your Honor. As mentioned, even if the area was not found to meet the requirements of curtilage, this search would still be a violation of the Fourth Amendment because my client had a reasonable expectation of privacy in her backyard. The Sheriff's Department had unrestricted access to all of the camera's content, which surveilled the entirety of Ms. Cobey's fenced-in backyard 24 hours a day for 200 days, a period of time which far exceeds any of the surveillance periods provided in the cases given in the case materials. Furthermore, my client's expectation of privacy was both subjective and it was reasonable, and it was an expectation of privacy that society would view as reasonable as well. Ms. Cobey left personal belongings in her backyard and had told Mr. Smith that he did not have permission to angle the camera in her backyard. However, he still ignored those requests from her. We can look at the case of People v. Weaver, in which the police installed a tracker on the defendant's van, which monitored its location for 65 days. The court in that case ruled that this prolonged surveillance, which captured data, what would have otherwise been uncollectible by police. Similarly, a police officer could not have been standing on a 10-foot tall post for 200 days without moving, capturing constant data on my client's backyard. Your Honor, technology has posed an increasing threat to privacy, making it even more imperative that we do what is necessary to protect it. Your Honor, this search was a violation of my client's Fourth Amendment right against unreasonable searches. And because of this, the defense respectfully requests that a motion be granted that images taken from this illegal video surveillance be inadmissible into court today. Thank you.
Thank you. At this time, I would like to invite argument from the prosecution.
Your Honor, for the purposes of the pretrial argument, the people may refer to Exhibits A and C. May I proceed?
Please go ahead.
May it please the court. My name is Michelle Giovinazzo, and I represent the people of California in this case. The people have stipulated that the placement of the camera was an act of law enforcement. However, the case of U.S. v. Caro outlines that even if a citizen acts as an agent, the resulting search is not necessarily intrusive. In the Caro case, the owner of cans of ether gave consent to the police to install a tracking device before delivery to the defendant. The court held, and I quote, "There was no meaningful interference with the defendant's interests in their possession." In the present case, the land clearly belonged to Mr. Smith, and he personally placed the camera. There was no meaningful interference with the defendant's privacy.
Oh, excuse me, counsel. Isn't having your every literal movement watched for over 200 days, isn't that a meaningful interference with your privacy?
First, Your Honor, it is important to note this was not constant surveillance. It is actually motion activated, and this is illustrated by the line on page 36, line 10, that an animal may have triggered the motion detector for the snake tongs picture to be taken. But second, the length of tracking is important to cases like Jones and Weaver, because the end result is knowing the defendant's whereabouts for long periods of time. But in this case, the end result is just one photograph, and that photograph could have been seen from a plane flying over, as in Dunn or Ciriolo. Garrett.
So let's talk about that. Isn't Ciriolo distinguishable because there the photos were taken from a public navigable airspace? Here, if you were to fly a plane over the public navigable airspace over this little backyard, I doubt that you would have been able to see Little Tongs. And you wouldn't have been able to fly a plane for 200 days to try and catch every little movement that happened in the backyard.
That is true, Your Honor, but as you can see from Exhibit C, the entire backyard abutted a public state park, and anyone in that state park could have seen the snake tongs if they wanted to. So thus, much like in the case of Ciriolo, this was visible to the public via the
Okay,
state.
so now, I'm sorry, now I have a question about the facts, because I just discussed with your distinguished opposition that it was not visible unless you actually stuck your head in over the gate and looked to one corner.
That is one way of seeing it, looking over the gate and looking around, which would not be an intrusion under the Fourth Amendment, especially considering this backyard was not considered curtilage under the four-way test of U.S. v. Dunn.
Okay, let me back you up just a little bit. Schaefer versus City of Boulder, 2012. There, the court says the police collected evidence that they could otherwise observe that they could not otherwise observe without physical intrusion. So here, this, if you didn't have the camera looking over the fence, the police would not have been able to see this without sticking their head over this gate and looking over to that corner. And sticking their head over that gate, crossing that line, isn't that a physical intrusion?
Not necessarily, Your Honor. In response to Schaefer, there are key distinguishing factors. The first being the severity, because in Schaefer, one of the cameras was pointed at a bathroom window. Now that could not be seen in any other way without a camera, but in this case, simply looking over the fence, which was only 6 feet high, is a possibility. The second important factor is the steps taken. U.S. v. Dunn outlines that is the fourth test for determining curtilage, and in Schaefer, the defendant repeatedly called the police, added plywood to the fence, but in this case, the defendant admitted to forgetting about the camera and made no such.
Okay. So we're talking about reasonable expectation of privacy. Isn't the existence of a 6-foot tall fence a statement saying, I expect privacy inside of this. I am renting the property inside of this. And you're saying that a 6-foot tall fence is not a symbol of an expectation of privacy, is not a reasonable expectation of privacy because someone could look over it?
Your Honor, this is outlined in U.S. v. Dunn as an important factor, the steps taken to protect the backyard. And unlike Schaefer, the defendant made no steps, and there simply was no reasonable expectation of privacy, given that they knew.
I'm sorry, again, we have, when you say the defendant made no steps, I thought part of the facts here is that the defendant asked Smith, the landlord, or told Smith, you don't have permission to take pictures, to have that camera up there and take pictures of what I'm doing in the backyard.
That is
isn't
true.
that a step?
The defendant asked one time over the course of 6 months, and this is in contrast to defendants like Schaefer, who repeatedly complained and added extra plywood. After asking, the defendant admitted to forgetting that the camera was even there. Thus, there is no reasonable expectation of privacy, and the defendant did not even expect that herself.
Okay, so forgetting about it means that you don't have an expectation of privacy even after you've taken steps and you're behind a 6-foot fence?
There were not sufficient steps taken, given that this could be. There were not sufficient steps taken, given that this could be seen by anyone in the public property of the state park.
I understand. Please continue.
Kara supported the earlier case of US v. Knotts. In Knotts, an employer consented to the installation by the police of a tracking device in a container of chloroform that was possibly contraband. The court held that the device did not serve any function that the police could not have performed visually. It just made the process easier. In the present case, Officer Garrett could have visually looked into the yard, either from the adjacent state park or Smith property.
I'm sorry, could the officer have could the officer have sat on top of a 10-foot pole for 200 days, which is far longer than the 65 days in the Weaver case, and figured out that image? I mean, we're not sure how long the tongs were there, right?
We are not sure how long the tongs were there, but it is possible that Officer Garrett could have come back to view the backyard periodically and would have seen the tongs then. But
by doing what? By jumping to look over the fence? By sticking his head over the gate?
Either of those methods would be able to see this snake tong. Ultimately, even if there was an expectation of privacy, this would make it similar to the barn in the Dunn case, where the court held that even if there was a reasonable expectation of privacy, because the police never entered, this was simply never violated. And similarly, Officer Garrett never entered the barn, never entered the yard, nor would he have to if he wanted to see these tongs.
Okay, but physical intrusion by itself isn't the only test, right? I mean, here we're talking about 200 days of 24/7 surveillance.
Again, Your Honor, it is not 24/7. And the fact that it is motion activated means that it could be more similar to periodically coming back to check up on the area. And further, the length of time is not important if the end result is just one photograph that could have been seen from anywhere in the state park looking into the gate, or from a flyover as in Dunn or Ciriolo.
Okay, so basically by your analysis, when would you have a reasonable expectation of privacy in a yard? When someone puts up a 10-foot pole, are you supposed to build up the fence even higher? Are you supposed to board everything up? Are you supposed to put a roof on it?
This is outlined as something that is important to the case in US v. Dunn. The important factor is that steps are taken and that there is an attempt. And here there simply was no attempt, especially considering the added factors of the public state park abutting the land, the open gate, and the obviousness of the camera. There simply would be no reasonable expectation of privacy.
Well, the words are yours, counsel, but you say here there was no attempt. But a minute ago, you were telling me that the steps taken were insufficient. So what exactly is the test? I thought in Dunn, it's the steps taken to protect the area, not whether those steps were successful, or there's no sufficiency test here, is there?
Well, under US v. Dunn, simply complaining once would not be considered sufficient steps taken. That would not be sufficient.
Can you show me in US v. Dunn where there was some kind of sufficiency test for the steps taken?
US v. Dunn simply outlines that there must be steps taken to protect the area.
Right. There's no sufficiency test discussed in that in what you have in that case, correct?
Well, it doesn't use the word sufficient. We can assume that the Dunn case would not recognize simply complaining once and then forgetting about it for the rest of the 6 months to be a sufficient step taken, or to really be a step taken at all.
Okay, I think I understand your argument. Please continue.
In California v. Ciriolo, the Supreme Court refined the concept of non-intrusiveness. It held that photos taken from the airspace over the curtilage of a person's home do not constitute a search, since any member of the public could have lawfully seen everything that the police photographer saw. In US v. Dunn, the Supreme Court held that a backyard, even one completely enclosed by a fence, is not automatically considered curtilage. The police intrusion in Dunn was far greater than in the case at bar. The police scaled a fence, shined flashlights into a barn on the property, and only then did they see contraband inside. Yet the court held that no warrant was necessary. It explicitly said that so-called open fields need neither be open nor fields, as long as they are unoccupied or undeveloped. In the current case, the sheriff was at no time on the property, and no photographs were taken of the interior of any structure. Under the reasoning of Katz v. US, the defendant had no reasonable expectation of privacy for the undeveloped and unoccupied backyard of a rented piece of property.
Katz versus US, that's a phone booth case, right? So I don't understand. I mean, there's a reasonable expectation of privacy of a conversation inside a phone booth, but I don't understand the analogy that you're making to support the search here.
Your Honor, this case would be similar to if Katz entered the phone booth with one wall missing and proceeded to have the conversation anyway. There simply is no reasonable expectation of privacy when these snake tongues could have been viewed by the obvious camera, the public state park, anyone in public airspace. Ultimately, the defendant had no reasonable expectation of privacy, considering that the tongues were in view, and this is outlined under serial law.
So, sir, when you say this is outlined under Cirolo, that's the photograph, a snapshot taking of an altitude at 1,000 feet from public navigable airspace. Your camera was not located in public navigable airspace, was it?
That is true, Your Honor, but
it wasn't a flyover search. It was a camera that was there for 200 days. And although you say it wasn't a 24/7 search, it was never off. It was motion activated, that's true, but the camera was there 24/7 for 200 days. Aren't those all distinguishing from Cirolo?
In response to the idea of duration, it is still the same end result as the case in Cirolo. Cirolo simply could have been repeated. There could be multiple flyovers every day or every week to achieve the same effect of having.
But that wasn't Cirolo at all. And so I'm not sure that it makes sense to say, well, let's take something that didn't happen in Cirolo and then apply it to this and say that's okay.
The reasoning of Cirolo still stays the same, that objects that can be seen by the public, whether that be from public airspace or a public state park, are not counted as a search because anyone in the public could have lawfully seen everything the police photographers saw.
I hear you. Please continue.
The defense argument might be valid if the camera had taken pictures of the inside of the defendant's house, as was the case in Kylo v. US, but that was never the case here. As the court can see from Exhibit C, Mr. Smith placed the camera on his own property, outside and well away from the defendant's fence, facing the see-through fence gate to the backyard. Neither Mr. Smith nor Officer Garrett ever entered that backyard, let alone the house that the defendant was renting. Both the facts and the law in this case are clear. The camera was lawfully placed, and the picture of the snake tongues was lawfully taken. There was no violation of the Fourth Amendment or California law.
30 seconds.
This court should deny the motion and allow the photograph of the snake tongues to be admitted into evidence. Thank you.
Thank you. Would the defense like to present a rebuttal argument?
Yes, Your Honor. May I proceed?
Please proceed.
Your Honor, opposing counsel brought up the case of U.S. v. Caro, in which a tracker was placed on a can of ether. But a can of ether is nowhere near as personal or as private as someone's backyard, and the expectation of privacy for both the can of ether and the backyard are nowhere near the same. Furthermore, opposing counsel mentioned that the camera was motion activated. And while it is true that the camera was motion activated, it was technically able to be activated 24/7. It remained on 24/7 for this period of 200 days. Whatever motion happened in the backyard would turn the camera on. Furthermore, opposing counsel brings up the case of Schaefer and says that Schaefer explains that my client did not take enough steps to prove that they had an expectation of privacy. However, Schaefer does not outline any specific steps to show this expectation of privacy or what sorts of steps are valid. My client expected her backyard, an area adjacent to her home, to be private. Why should we place a burden on her to take futile steps to protect her backyard that she believed to be private because it was an area so close to her home? Furthermore, opposing counsel stated that this camera, all it did was replace an action that the officer could have performed visually. However, the defense would argue, how would the officer have known exactly when the tongs would have been there? We must recognize how important of a role the camera played. The camera, using motion-activated technology, was able to be turned on whenever motion was activated. So would the officer be alerted whenever motion happened in the backyard and rush to the scene? No, clearly the camera performed a function that went beyond what the officer could have done. Your Honor, this search was a violation of the Fourth Amendment. Therefore, the defense again respectfully requests that our motion be granted, that Exhibit A be inadmissible into trial today. Thank you.
Thank you. Would the prosecution like to present its rebuttal?
Yes, Your Honor. Opposing counsel first says this is clearly curtilage under the four-part test outlined in Dunn. But this area would clearly fail at least the fourth part of the Dunn test, which is the steps taken to protect the area. In the present case, this backyard abutted a state park. The camera was in plain view and the defendant had 6 months to take any action. But she only complained once and then herself admitted to forgetting the camera was there. Clearly, this would not meet the test of steps taken to protect the area in question. Opposing counsel also cites Romero, but Romero is easily distinguishable as there was no physical intrusion in the present case, while there was in Romero. Even if this was considered curtilage, which the people do not concede it is, this would be more similar to the barn in the Dunn case, where even if there was a reasonable expectation of privacy, it was ultimately not intruded into because the police never entered the barn, they simply looked in. Next, they cite the length of time. But the length of time is really important in cases like Jones and Weaver that involve tracking, but not in cases that end result is just one photograph that could have been from a repeated flyover or simply going back to check on the property every once in a while. Ultimately, there was no reasonable expectation of privacy within the view of an obvious camera and a public state park. And the defendant herself understood this as she forgot that the camera was even there. Ultimately, the facts and the law are clear. There was no violation of the Fourth Amendment or California law. I ask that this court deny the motion and allow the photo of snake tongues admitted into evidence. Thank you.
Thank you. Before I give my decision on the pretrial motion, I would like to pause and allow the attorney scorers to score the pretrial motion.
Ray Robinson, Dunn.
Alice Lester, Dunn.
Mr. Phillips, Dunn.
Kendra Pappas, Dunn.
Thank you. Also, I want to remind you to take both fill in the computer ballot and also keep a paper ballot of your scores. At this time, I will announce that I'm going to grant the pretrial motion and suppress the photograph of the tongs. They are not to be used in the trial nor referred to. And I find that there is an actual subjective expectation of privacy and that it was reasonable, that the area was within curtilage based on the fourth step that was argued by counsel, that there were steps taken to protect the area from observation from passersby. I think that the argument regarding that there were steps taken in terms of Cobey telling Smith that Smith did not have permission to photograph the area and the position of landlord-tenant making it difficult for a person in the tenant's point of view, that is Cobey's perspective, to continue. I think the steps that were taken were reasonable and puts the area within curtilage. In addition, This was a place that was not viewable without physical intrusion into the yard by sticking your head over the chain link fence. And this was a significant intrusion in terms of that it was the entire backyard and that it was 200 days. Although it was argued that it was stop motion, that camera was on all the time, and it wasn't as if there was privacy only by standing still, and that decreased the intrusiveness of the camera in this case. So the motion is granted, and at this time, I would like to invite opening statement by the prosecution. Oh, I'm sorry, there's a rules conference, a 1-minute rules conference. Can you start timing the 1-minute rules conference? Are there any rules violations to report from the prosecution?
No irregularities, Your Honor.
Are there any rules violations to report from the defense?
No irregularities, Your Honor.
Thank you. The people of the state of California charge the defendant, Jamie Cobey, with first-degree murder or voluntary manslaughter of Eric Smith. I would like to invite opening statement from the prosecution.
Before we begin, Your Honor, the people have some preliminary matters to address.
Okay.
Exhibits A through E have been marked for identification and have been reviewed by both sides. Additionally, the people bring to the court's attention the agreed upon stipulations set forth on pages 14 through 16 of the case packet. May I proceed, Your Honor?
Yes, you may.
This is what the evidence will show. The defendant blamed Eric Smith for the death of a beloved mother and used a cold-blooded rattler to kill him. Revenge, best served cold. Someone least expects it. For a decade, Eric Smith and the defendant were neighbors. As the defendant's landlord, it was no secret that the defendant disliked Smith. They harassed each other. The police were called regularly. The defendant was also a landscaper, familiar with the desert's poisonous snakes. The defendant had all the protective gear and tools necessary to trap and then release. The defendant also knew that the 70-year-old Eric Smith suffered from serious kidney and heart disease. But in April of last year, the situation worsened. Smith temporarily shut off the electricity in response to an ongoing rent dispute. The defendant's mother lost power to her oxygen machine and later died. The defendant blamed Smith. Several days later, at her funeral, Smith came to pay his respects. A heated argument broke out, and the defendant yelled at Smith, "You killed my mother!" Later that day, retired lawyer Terry Edwards saw the defendant working in the garden during dusk, a time when snakes are known to be out. The defendant claimed to be finishing something important, and then screamed, "I'm going to kill him." The following day, on April 29th of 2021, line worker Angel Russell was working on a power pole. She saw the defendant go to Smith's mailbox carrying a large tool bag along with an animal trap. The defendant repeatedly worked down on this trap. The only other person Russell saw that day was Eric Smith. Around noon, Smith opened his mailbox and was bitten by the deadliest rattler in North America, a Mojave, missing its rattle. A jar of rattles was later found by the police in the defendant's house. Smith died later that evening from the highly toxic venom. at a bare minimum. The heat of passion establishes manslaughter under Cal Crim 570. Yet, at the core, Your Honor, this is first-degree murder, pursuant to Cal Crim 520 and 521. An intentional act, using a deadly rattlesnake, silenced with its rattle cut off, committed with the requisite mental state of malice and with an ample period of days for deliberation, premeditation, and a time to cool off. Cold, planned, exacting. Revenge, desert style. Thank you.
Thank you. May I invite opening statement from the defense?
Yes, Your Honor, may I proceed?
Yes.
Eric Smith's unfortunate death was not the killing of one human by another. It was a tragic but accidental death at the hands of Mother Nature. Jamie Cobey is a loving friend, daughter, passionate gardener, and patient tenant. And while she had endured a great deal of harmful behavior from her landlord, Eric Smith, she never responded in an aggressive or violent manner. On April 22nd, Jamie's mother was sent into cardiac arrest due to a lack of oxygen after Mr. Smith once again shut off Jamie's electricity. Jamie's mom died that day, yet she carried on without displaying any sort of violent behavior. She put her energy into planning her mother's funeral and even continued paying her rent. That's what she was doing on April 29th. During the course of the trial, the prosecution will fail to prove beyond a reasonable doubt that Jamie Cobey is guilty of any crime. Jamie loved her mother and cared deeply for her well-being. So when Mr. Smith showed up uninvited to her mother's funeral on April 28th, Jamie was understandably upset. Following the funeral, Jamie visited her longtime neighbor and friend, Frances Yazzie, for emotional support. Ms. Yazzie will testify today that Jamie is a patient, devoted, and loving person. On the next day, April 29th, Mr. Smith reached into his mailbox and was bit by a Mojave rattlesnake that was coiled inside. Dr. Tyler Clay, a herpetologist, will testify that the rattlesnake's presence in the mailbox is not unusual based on the Mojave rattlesnake's behavior of climbing to dark, tight spaces to get away from sunlight. He will also testify that it would be an extremely risky action for someone holding an animal trap to dump a rattlesnake into an open mailbox. Lastly, the actions following the bite were exacerbating causes of the death of Mr. Smith that could not have been planned nor predicted by Jamie. First, Miss Russell wasted time searching for and killing the snake rather than immediately assisting Mr. Smith. Mr. Smith also got up and began moving after being bitten by the snake, allowing its venom to course through his blood quicker. On June 3rd, 2021, Jamie was arrested for the death of Mr. Smith. Danny Emling, another tenant of Mr. Smith, was shocked to hear of Jamie's arrest. He will testify that Jamie often dealt with her problems with Mr. Smith in a non-violent manner by calling the sheriff, going to vent to Mr. Emling, and even apologizing to Mr. Smith. Jamie could not have planned nor predicted the sequence of events that led to the death of Mr. Smith. His death was an unfortunate but accidental death at the hands of Mother Nature, not Jamie Cobey, which is why at the conclusion of this trial, the defense will respectfully request a verdict of not guilty. Thank you.
Thank you. At this time, I'm going to pause and allow the attorney scorers to score the opening statements.
Ray Robinson Dunn.
Alice Luster Dunn.
Kendra Pappas Dunn.
Mr. Phillips Dunn.
Thank you. And please double check that you have both a computer score and something on a notepad near you. Okay. Prosecution, you may call your first witness.
The people call Deputy Sheriff Garrett to the stand.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the record, please state your name and spell your last name for the court.
Tony, Garrett.
Thank you.
You may inquire.
Before I begin, Your Honor, the people will be referring to Exhibit B during this examination. May I proceed?
Yes.
Good evening.
Good evening, ma'am.
Please tell us about your background.
Well, I've been deputy sheriff for the county of Burnsley for the last 20 years.
Deputy, do you recall responding to an incident in April of 2021?
I do, at the victim's house out on 46601 Raptor Road.
Did you observe anything there?
Yes, ma'am. Mr. Smith was lying face down and had no pulse.
Did you interview anyone at the scene?
I did, Angel Russell, a linebacker.
And what did you learn?
Well, Russell said that they were on a power pole when she saw Mr. Smith get bit by a rattler while getting mail.
Did Russell see anything else?
Miss Russell saw a person carrying a wired cage and a tool bag exit 46603 Raptor and then stand by Mr. Smith's mailbox.
Do you know who lives at 46603 Raptor, Deputy?
The defendant.
Other than Smith and the person exiting 46603 Raptor, did Russell see anyone else that day?
She did not.
Now, were you aware of any troubles between the victim and the defendant?
I was. I personally responded to a number of these calls.
And did you try to resolve these problems?
Well, I suggested mediation, and finally I gave Mr. Smith a department camera after an allegation of trespass.
So, how did your investigation proceed?
Well, I first examined the mailbox, and then I dusted it for prints.
Deputy, do you recognize Exhibit B?
Yes, ma'am. It is a picture of Mr. Smith's mailbox.
Is it a true and accurate depiction?
Yes, it is.
Your Honor, the people request that Exhibit B be moved into evidence.
Any objections?
No objections, Your Honor.
Exhibit B is admitted.
Did your inspection of the mailbox raise any concerns?
Yeah, well, I was concerned that the bite may not have been an accident.
Were any prints recovered on the mailbox?
There were the defendant's, another tenant named Danny Emling who had a confirmed alibi, and Mr. Smith's.
Did you ever find anything in Smith's house?
I did. I found several rent checks from tenants, but nothing from the defendant.
Did you ever speak to the defendant?
I did. The defendant claimed to be dropping off rent while carrying an animal trap.
Did the defendant make any statements about Smith close to the incident?
Yes, the defendant told Smith, quote, "You are the reason for my mother's death." Later, she told a neighbor, "I am going to kill him."
Were any items significant to the investigation found inside the defendant's home?
Well, I found a gardening tool bag, as well as a container with rattlesnake rattles.
Was there anything unusual about the rattlesnake that bit the victim?
Ma'am, it was missing its rattle.
Did you ever examine the defendant's animal trap?
I did not. The defendant actually sold the cage, as well as some other tools, shortly after Mr. Smith died.
So what did you do next?
Well, I requested and I obtained an arrest warrant for the defendant.
Thank you, officer. No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Good evening, Deputy Garrett.
Good evening, ma'am.
You've known Eric Smith for the past 20 years, correct?
That is correct. Yes.
Mr. Smith was well known for his expertise in desert living, right?
That is correct.
You've known Jamie Cobey since she moved to Burnsley with her mother about 10 years ago, right?
Yes.
and you have personally responded to half a dozen complaints from either Mr. Smith or Ms. Cobey, right?
That is correct, ma'am.
At one point, Mr. Smith admitted to provoking Ms. Cobey with rude outbursts or playing loud music and damaging Ms. Cobey's prized cacti, right?
Yes, that is correct.
Mr. Smith had a reputation for being rude to fellow council members and to residents speaking in front of the council, correct?
Objection, Your Honor. Improper character evidence, and may I be heard?
First, okay, go ahead.
First, on page 79 of the mock trial rules, character of the victim is allowable, but it must be showing that that victim acted in accordance with his or her character evidence on a specific occasion, where the victim's character would tend to prove the innocence of the defendant. Opposing counsel is asking about the reputation of the victim while not providing any specific occasion or tendency that would lead to prove the innocence of the defendant.
Counsel, did you wish to respond?
Yes, Your Honor. The defense is eliciting character evidence in the form of evidence of reputation, which is admissible. In this case, the specific character trait being elicited is that Mr. Smith was rude to fellow council members, which has a tendency to prove the defendant's innocence, seeing is that it provides motive for other members of the community to commit this crime.
Your Honor, may I respond?
Yes.
While opposing counsel did provide this character evidence in the form of an opinion, evidence, or reputation, that is not the only requirement for character evidence of the victim to be admissible. It states on lines 4 through 7 of page 79 of the case packet, it's discussing the victim's character and says that this evidence may only be used to prove the victim acted in accordance with his or her character on a specific occasion. So while opposing counsel is saying that it will prove the innocence of the defendants, their testimony is not describing any specific occasion of this happening.
Did you wish to respond? Counsel
Yes.
Bate?
Nothing further, Your Honor. Matter submitted.
Okay, is the matter submitted?
Yes, Your Honor.
Okay, give me just 1 second. The objection is sustained. Your next question?
Your Honor, move to strike.
That Smith was rude to council members, that answer is stricken.
Deputy Garrett, last October, you responded to a complaint from Mr. Smith because he claimed Ms. Cobey broke into his house, correct?
That is correct. October 10th, if I recall.
But there was no evidence of a break-in by Ms. Cobey, was there?
No, none directly I could find.
Despite the lack of evidence, you gave Mr. Smith a state-of-the-art motion detector security camera, correct?
Exactly. I wanted to look further into the investigation.
You showed Mr. Smith how to set the camera up on a pole on his property, correct?
Yes, that is correct.
The camera was to help catch my client coming into Mr. Smith's gate, right?
Yes, it was just in case of the trespassing allegation.
You even showed Mr. Smith how to share footage with the police department, correct?
Well, we gave Smith the choice, yes.
You interviewed Ms. Cobey on May 2nd, correct?
That is correct.
Ms. Cobey gave you permission to look around her property when asked, correct?
She did.
In fact, while you were looking around, Ms. Cobey was outside gardening, wasn't she?
Yes, she was.
You spotted animal handling gloves and snake-proof boots in Ms. Cobey's garage, right?
That is correct.
These items were in plain view on a table when you glanced into the garage, correct?
I do not recall the exact placement of the item.
Deputy Garrett, do you recall making a witness statement?
Yes, I do.
Directing the court's attention to page 37, lines 19 through 22, it reads, my apologies, lines 9 through 12, it reads, on my way out, I glanced into the garage, which was located off the kitchen. There, I saw a table on which I found a pair of animal handling gloves, a long-sleeved shirt, and what I recognized to be snake-proof boots. Is that correct, Deputy?
That is correct. Yes, my apologies. That is in my statement.
Deputy Garrett, you received a forensic report that fingerprints from Ms. Cobey, Mr. Smith, and Danny Emling were found on the front door of Mr. Smith's mailbox, correct?
That is correct.
But there is no way to determine the precise time when these fingerprints were left on the surface, correct?
I'm afraid not, no.
Thank you, Deputy Garrett. Nothing further, Your Honor.
Does the prosecution wish any rebuttal?
Yes, Your Honor. May I proceed?
Yes.
Deputy, what happened after you gathered evidence in this investigation?
Well, I obtained an arrest warrant for the defendant.
Thank you, Your Honor. No further questions at this time.
Thank you. I'm going to pause to allow the attorney scorers score the both attorneys and the witness.
Ray Robinson, done.
Alice Luster, done.
Mr. Phillips, done.
Kendra Pappas, done.
Okay. And remember, it's the witness is Tony Garrett. On my ballot, the next witness was Charlie Dunn. So make sure you're scoring the correct witness. And please make sure you have a hard copy as well as the computer copy. Would the prosecution please call their next witness?
At this time, Your Honor, may this witness be excused?
Yes.
Your Honor, the people call Angel Russell to the stand.
Angel Russell, please turn on your camera. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the record, please state your name and spell your last name for the court.
Angel Russell, Russell.
Thank you.
Your Honor, for the purposes of this exam, the prosecution will reference Exhibit C. May I proceed?
Yes, you may. Thank you.
Good evening.
Good evening.
Are you employed?
Yeah, I've been a line worker in Burnsley County for about 15 years.
Did you know the victim, Eric Smith?
Well, I've seen him around town, but really nothing more than that.
Were you working on April 29th, 2021?
I was working a power pole job out on Raptor Road.
Do you recall anything unusual happening that day?
Well, at about 8:30 in the morning, I saw a person leaving the neighboring house at 46603 Raptor Road.
Do you recognize Exhibit C?
Yeah, it looks like an overhead map of the houses and the power pole that I was working on Raptor Road.
Is it a true and accurate depiction?
Yeah, it is.
Your Honor, the people request that Exhibit C be moved into evidence.
Any objection?
No, Your Honor.
Exhibit C is admitted.
So back to the person who left the house located at 46603. Was this person carrying anything?
Yeah, like a medium-sized wire cage of sorts.
What else did you see?
Well, I saw this person carrying the cage, look down at it a few times.
Was there anything in the cage?
I don't remember.
Did this person have anything else with them?
Yes, like a gardening type tool bag. It was a really bulky thing.
Do you know where this person went?
I saw them standing right next to Smith's mailbox.
Did you recognize this person?
Yeah, it was the defendant sitting over there.
What happened next?
Well, at around noon, I saw Smith come out of his house.
Did you see where Smith went?
I saw him open up his mailbox and he reached in.
Then what occurred?
Well, Smith started screaming and he yanked his hand out of the box. I looked over and he was trying to shake the snake off of his wrist.
Did you do anything?
Heck yeah, I did. I got down the pole and I saw it was a rattler. I panicked some, but then I got a breaker bar out of my truck and I bashed the thing to death.
Did Smith say anything?
He screamed, "Jamie."
Objection, Your Honor. This is more prejudicial than probative.
Your Honor, may I respond?
Yes?
Your Honor, this is not more prejudicial than probative because this is going to the relevancy, not the bias. And in this case, the defendant's response is not biased. It's just, it's not biased against the defense, and it's just establishing what Jamie Cobey said.
Your Honor,
And
Your Honor, may I be heard?
Yes?
Your Honor, this is bias against the defense. Mr. Smith was completely speculating that my client was the perpetrator or had something to do with this by saying his name. If this statement is allowed in, this baseless belief could prejudice the trier of fact's decision on whether or not my client is guilty of murder.
Your Honor, may I respond?
Yes?
On page 75, lines 8 through 12 of the mock trial case packet, more prejudicial than probative reads, the court in its discretion may exclude relevant elements if its probative value, its value as proof of some fact, is substantially outweighed by the probability that its admission creates substantial danger of undue prejudice, confuses the issues, wastes times, or leads the trier of fact. Your Honor, according to this definition of the objection in this case packet, which I just read aloud, this is not more prejudicial than probative. It might be damaging, but that is not more prejudicial than probative. This question is not meant to affect the court's impartiality.
Well, can I ask you then, what is the probative value of Smith shouting Jamie?
Yes, Your Honor. This goes to Mr. Smith's observation after being bitten in this case, which is highly relevant and is the center of this case.
He wasn't saying anyone who was there, right? It's just that he screamed Jamie. So what is the probative value of that statement?
Your Honor, this is the initial reaction after being bit by a snake, which goes to the history of dispute between Jamie and Eric Smith. It shows the motive of Jamie Smith and because of their conflict and why he would have reason to murder Eric Smith.
You mean Jamie Cobey?
Yes, Your Honor.
Okay. And okay, I would like to ask the defense attorney the same question. What is the probative value of this evidence?
Your Honor, I do not believe that there's a good probative value of this evidence. I believe that the prejudicial value of this evidence farly outweighs the probative value, and this should therefore be stricken from testimony.
Okay.
Your Honor, may I respond?
Okay.
Your Honor, this is not undue prejudice because it is not damaging. Indeed, the best trial evidence is always to some degree damaging to the opposing side's case. Undue prejudice instead is prejudice that would affect the impartiality of a judge, usually through provoking emotional reactions. Page 73, lines 15 through 19. Your Honor, according to the definition of this objection of the case packet, which I just read aloud, this is not more prejudicial than probative. It may be damaging, but this is not more prejudicial than probative. This question is not meant to affect this court's impartiality, which is at the heart of more prejudicial than probative.
Anything further, or is the matter submitted?
The matter is submitted, Your Honor.
Counsel?
Nothing more at this time, Your Honor.
Thank you. The objection is overruled, and the definition of the undue prejudice objection is what guides the court's decision in this matter. The objection is overruled.
What happened after you killed the snake?
Well, I tried to settle Smith down. He was kind of dazed. And then I remembered this TV show about sucking venom out of wounds, so I tried that.
What occurred next?
Well, Smith didn't want to go to the doctor. He said he'd just tough it out.
Did you ever go back to Smith's house?
I did. The next day I went to finishing working the power pole line.
Did you see Mr. Smith?
I did. The poor guy was in his pajamas face down in the dirt. The front door was wide open like he had just run out and collapsed. I called for help and finally the deputy sheriff came.
Thank you. Nothing further.
Cross-examination?
Yes, Your Honor. Good evening, Ms. Russell.
Good evening.
On April 29th at 8:30 a.m., you were working down the road from 46601 Raptor Road, correct?
Yes, that's correct.
You knew this to be at the address of Eric Smith, right?
Yeah, I did know that.
You were working 100 feet away from Mr. Smith's residence at the time, right?
Yes.
You had just climbed up a power line pole, isn't that true?
Mm-hmm. That was the job I was being paid to do.
After you climbed up the power line pole, you saw Miss Cobey standing in front of Mr. Smith's mailbox, right?
Yeah, I did.
Miss Cobey was carrying what appeared to be a cage, right?
Yeah.
You can't remember if there was anything inside that cage, can you?
No, I don't remember.
This person was also carrying a tool bag, isn't that right?
Yes, she was.
You couldn't identify the items in that bag either, isn't that true?
No, I just know that it was really bulky.
You didn't see the person open or close the mailbox, right?
No, I didn't see that either.
Later that day at around 12 p.m., you saw Mr. Smith come out of his residence, correct?
Yes, I did.
Soon after that, you saw Mr. Smith reach into his mailbox and step away screaming, right?
Yeah.
You saw Mr. Smith trying to shake a snake off his wrist, correct?
That's correct, yeah.
You hit the snake with the breaker bar and killed it before helping Mr. Smith, correct?
Yes, I did do that.
After that, you also tried sucking the venom out of Mr. Smith's wound, correct?
Yeah.
You suggested that Mr. Smith go to a doctor immediately, right?
Yeah, of course I wanted him to.
But Mr. Smith said this was unnecessary, didn't he?
He did.
You saw letters fall out of Mr. Smith's mailbox, correct?
I saw envelopes, yes.
After the incident, Mr. Smith picked up the letters and went inside, right?
Yes, he did.
You found Mr. Smith the next day lying face down on the ground with no pulse, correct?
That's correct, yes.
Thank you, Your Honor. No further questions.
Thank you. Any redirect examination?
Yes, Your Honor. Were you looking at the mailbox the entire time the defendant was there?
No, I was mainly focusing on my work.
Thank you. Nothing further.
Thank you.
Your Honor, may this witness be excused?
Yes, and I'm going to pause to allow the attorney scorers to score the examination of Angel Russell.
Ray Robinson, done.
Alice Luster, done.
Kendra Pappas, done.
Mr. Phillips, done.
Thank you. And just a little reminder to keep your hard copy scores also. Would the prosecution please call their next witness?
The people called Dr. Dunn to the stand.
Dr. Dunn, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the record, please state your name and spell your last name for the court.
Dr. Charlie Dunn, D-U-N-N.
Thank you.
Before I begin, Your Honor, the people will be referring to Exhibit D during this examination. May I proceed?
Yes, you may.
Good evening.
Good evening.
How are you employed?
I've been the chief medical examiner of Burnsley County since 2015.
Please briefly describe your background.
I have a medical degree from the University of California with specializations in toxicology. My fellowship was in forensic toxicology, which included familiarity with venomous and poisonous creatures.
As a medical examiner in a desert community, do you keep abreast of information in the field with respect to venomous bites?
I do.
Did you perform any work on this case, Doctor?
Yes, I started with a visual examination of the victim.
And what did you observe?
I found 2 red and swollen puncture wounds on the left wrist that were clearly from a snake bite.
Did you learn how the victim was bitten?
The rattlesnake was in the mailbox.
Doctor, based on your training and experience, where are venomous snakes typically encountered?
Objection, Your Honor. This question lacks foundation as an improper expert opinion.
Your Honor, may I respond?
Yes, you may.
This expert is qualified to testify to where snakes are encountered because first, they specialize in toxicology. They had a fellowship in forensic toxicology and had to know a lot and research a lot about snakes from their studies. Additionally, this witness is the chief medical examiner in a desert community, and part of this job is knowing where, how, and when snakes are encountered and snake bites happen. So it is very reasonable that this doctor has the knowledge of the circumstances of bites in Bernsley County.
Any response?
Yes, Your Honor. As opposing counsel mentioned, this expert witness has qualifications only in toxicology, clinical toxicology, and forensic toxicology. Any reasonable person living in desert communities may have opinions as these. However, it is an improper expert opinion for this expert witness to testify to the behavior of snakes when they have no qualifications with herpetology and they're attempting to establish an expert opinion in this case.
Your Honor, may I respond?
Yes.
This witness did have a fellowship in forensic toxicology, which meant they had to research snakes and snake behavior in their studies. Additionally, this witness knows statistics and keeps up with information of snake bites. They know the number of people seeking medical care and getting bitten and dying. And with the addition of their research and their fellowship, they're very qualified. Additionally, their profession is being the chief medical examiner of Bernsley County. A chief medical examiner needs to know the situations and encounters of bites because this is a desert community where venomous creatures are often encountered.
Your Honor, may I respond?
Yes.
Your Honor, once again, this expert witness is the chief medical examiner. This expert witness does not have qualifications in herpetology and thus is not qualified to testify to the behavior of snakes from an expert standpoint. Although they do have experience in the desert with their role as a medical examiner, their qualifications are surrounding the causes of death and the medical aspects regarding these venomous bites rather than the behavior of snakes, and thus this isn't a proper expert opinion.
Your Honor, may I respond?
Submitted? You may respond, but please don't repeat anything that has already been said. If it's already been said, you don't need to repeat it.
Yes, Your Honor. I would just like to add one thing, that on stipulation 5, stated on page 15, lines 7 through 8, it states that these expert witnesses may testify to any relevant information they would have reasonable knowledge of. And as I have stated that the encounters of snakes is reasonable knowledge, they can therefore provide this testimony.
Anything further?
Yes, Your Honor. Opposing counsel has brought up the stipulation regarding reasonable knowledge. However, I do not think that testifying, giving an expert opinion as to the behavior of snakes from an unqualified standpoint would count as reasonable knowledge.
Is the matter submitted?
Yes, Your Honor, matter submitted.
Yes, Your Honor.
Excellent arguments by both lawyers. The objection for foundation is sustained.
Motion to strike the question, Your Honor.
Granted.
Doctor, was the inside of the mailbox cooler at the time of this incident?
No, the temperature on the date in question was 68 degrees, both inside and outside the mailbox.
Did you also examine the snake, Doctor?
Yes, it was a Mojave rattlesnake, 2 feet long and 2 inches wide at its widest diameter, with its rattle missing.
Do you recognize Exhibit D?
It's a picture of the snake that I took.
Is it a true and accurate depiction?
Yes, it is.
Your Honor, the people request that Exhibit D be entered into evidence.
Any objection?
No objections, Your Honor.
Exhibit D is admitted.
Do rattles fall off in the wild?
They do, but it usually takes a good deal of force.
Does the venom of the Mojave rattlesnake contain toxins?
Objection. The venom actually
bleeding.
I'm sorry.
This question.
I didn't hear the objection.
A leading question.
Sorry, what was the current question?
The question was, does the venom of the Mojave rattlesnake contain toxins?
Sustained.
Motion to strike the question, Your Honor.
Granted. Could you ask another question, please?
Yes, Your Honor. How does the venom of the Mojave rattlesnake compare to other species?
The Mojave rattler is 16 times more venomous than other rattlesnakes.
Doctor, did you perform an autopsy on Mr. Smith?
I did. The victim had tubular necrosis of the kidneys. A snake's toxins can exacerbate pre-existing conditions, but in most cases, the necrosis or tissue death is a direct cause of the bite.
Were any other organs compromised?
The victim's heart had experienced epicardial hemorrhaging or bleeding. Again, this is often the direct result of the snake bite itself.
So, doctor, did any pre-existing medical conditions of Mr. Smith cause his death?
No, Mr. Smith would have died from the venom irrespective of any underlying condition.
Thank you, doctor. No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Good evening, Dr. Dunn.
Good evening.
You've been the chief medical examiner for Bernsley County since 2015, correct?
Yes, that is correct.
During the 6 years that you've been in this position, you've only examined 3 deaths due to venomous bites, correct?
Yes, that is true.
Of those 3 deaths, only 1 was from a snake bite, correct?
Yes, only 1.
And Dr. Dunn, it is rare to die from rattlesnake bites, right?
Yes, unless you get immediate access with antivenom.
In fact, out of the estimated 7,000 to 8,000 people that are bitten by venomous snakes each year, only about 5 of them die, correct?
Yes, without proper medical care, the number would be much higher.
Dr. Dunn, in this case, Angel Russell witnessed Mr. Smith being bitten by the snake, correct?
Yes, it is true.
Miss Russell suggested that Mr. Smith seek out medical care, but Eric didn't, right?
Yes, that is correct.
And when Miss Russell found Eric Smith, she looked for the snake before helping Mr. Smith, correct?
Yes, I recall that.
Russell tried sucking the venom out of Mr. Smith's wound, correct?
Yes, but in my professional opinion, that did not contribute to his death.
Mr. Smith also got up and began moving around after he was bitten, didn't he?
Yes, he did.
And yes or no, Dr. Dunn, you agree that all 3 of these intervening factors are ill-advised, correct?
Yes, they're ill-advised.
Thank you, Dr. Dunn. Thank you, Your Honor. Nothing further.
Thank you. Any redirect?
Yes, Your Honor. Doctor, is there any question in your mind as to what killed Eric Smith?
No, the victim died as a result of the Mojave's deadly toxins.
Thank you, Your Honor. No further questions at this time.
All right, thank you. I'm going to pause so that we can, please let me know when you've scored the examination of Dr. Charlie Dunn.
Alice Lester Dunn.
Ray Robinson Dunn.
Kendra Pappas Dunn.
Mr. Phillips Dunn.
Thank you. So I'm going to enter my computer ones. Please make sure you have backed up your scores in hard copy. All right, would the prosecution please call their last witness?
At this time, Your Honor, may this witness be excused?
Yes.
Your Honor, the people called Terry Edwards to the stand.
Terry Edwards, please turn on your camera. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the record, please state your name and spell your last name for the court.
Terry Edwards. Edwards is EDWARDS.
Thank you.
Your Honor, before I proceed, the people respectfully request a time check.
Yes, the prosecution has 3 minutes and 55 seconds remaining, while the defense has 3 minutes and 3 seconds remaining.
Your Honor, before we proceed, I'm the shadow timer. I would like to bring up a timing inconsistency.
Okay.
I believe that after this past direct examination, there were 3 minutes and 55 seconds. However, after the cross-examination, there were only, or my apologies, Your Honor, after the redirect examination, there were only 3 minutes and 36 seconds, as that examination was 20 seconds.
Your Honor,
what does the
may I
main
confer with
timer?
the shadow timer, please?
Yes.
Well, after the main examination, I had 4 minutes and I had the redirect at 5 seconds.
I had the redirect as 21 seconds. That is more than 15 seconds and therefore should be brought up into trial.
Does the shadow timer want to see my sheet?
If you could just say the time used for direct examination, that would be wonderful.
All right, so for the first direct on the prosecution, I had 3:42, then I had 3:07 and 3:04. For the defense, the first cross was 3:15, then 2:04 and 3:03.
Can you say the witness 3 direct examination time without redirect, just direct?
Yes, I had 3 minutes and 4 seconds.
3 minutes and 4 seconds. And prior to that, how much time was left?
7 minutes and 4 seconds.
Okay, thank you.
So do the timers now agree on how much time is left for prosecution and defense?
Yes, Your Honor.
Okay, and what are those times?
The prosecution still has 3 minutes and 55 seconds, while the defense still has 3 minutes and 3 seconds.
3 and 3? 3 minutes and 3
3:55
seconds.
for the prosecution and 3 minutes and 3 seconds for the defense.
So I'm sorry, for the defense, is it 3 minutes and 30 seconds and 3 minutes and 3 seconds?
No, Your Honor. The prosecution has 3 minutes and 55 seconds, and the defense has 3 minutes and 3 seconds.
Okay, all right. And the shadow timer agrees?
Yes, Your Honor.
Okay, great. Let's see. Has Terry Edwards been sworn in?
Yes, Your Honor.
Okay, then prosecution counsel Milmo, please proceed.
Good evening.
Good evening.
Are you employed?
Not now. I'm retired from the practice of law.
Did you know the victim?
I did. I was friends with Eric. I've lived down on the road after for 10 years, and I've been neighbors with both Eric and Jamie.
Can you describe the relationship that Eric had with the defendant?
I can. In short, they didn't like each other.
Do you remember attending a funeral in April of 2021?
I do. It was for Jamie's mother, who was a very nice woman.
Do you recall anything unusual happening?
There was an argument between Eric and Jamie.
Can you describe what you saw?
When I first got to the funeral reception, Jamie appeared angry. I heard yelling and shouting and thought there would be a fight.
Did you hear the defendant say anything?
Jamie said that this was it and that he was finally going to do it.
Did you hear the defendant say anything else?
Jamie shouted, "You weren't invited here. My mom hated you."
Did Smith respond?
Eric kept saying, "I'm sorry for your loss," but Jamie just got madder.
What happened next?
Jamie clenched his fist and shouted at Eric, "You killed my mom."
Did Eric respond?
Eric stated, "Me? It's your fault your mom died. You should have taken better care of her."
Did you try to intervene?
Absolutely. It was a funeral, and there was going to be violence between the two. So I stepped in. I got them to
Objection, Your Honor. Calls for speculation.
Your Honor, may I respond?
Yes.
Your Honor, this witness has lived on the same road as both Eric Smith and Jamie Cobey for 10 years. they would have reasonable knowledge of Eric Smith and Jamie Cobey's relationship and would therefore be able to testify to when they were going to have an argument that would turn into a fight.
Your Honor, may I be heard?
Yes.
Despite the fact that Miss Edwards is familiar with both Mr. Smith and Miss Cobey, she cannot testify to the fact that there was going to be violence between the two of them. She does not have reasonable knowledge of this.
Your Honor, may I respond?
Yes.
Your Honor, this witness has witnessed disputes between Jamie Smith and Jamie Cobey, and considering the situation of the funeral wherein they were getting into a large fight, it is reasonable that this witness would assume that Jamie Cobey and Eric Smith would become violent as both were experiencing heightened emotions.
Anything further?
Yes, Your Honor. This witness has never observed a violent altercation between Miss Cobey and Mr. Smith. Additionally, she only witnessed the two of them making statements to one another, never any violent behavior.
Your Honor, may I respond?
Yes.
While this witness only has experienced disputes between the two of them, many of these altercations included screaming statements and have made large scenes, so it is not unreasonable for this witness to assume that there was going to be violence.
Is the matter submitted?
Submitted, Your Honor.
Submitted, Your Honor.
The objection speculation is sustained.
Motion
As phrased, in terms of that statement, it's sustained.
Motion to strike the statement, Your Honor.
The statement there was going to be violence between them is stricken.
Did you ever see Eric again?
No, when Eric drove off, that was the last time.
How about the defendant?
Well, I was concerned, so I drove by Jamie's house. When I got there, I rolled down my window.
What occurred next?
Jamie screamed, "I'm going to kill him."
Did the defendant say anything else?
He said there was important work in the garden to finish.
Was there anything unusual about the defendant's conduct?
Well, it was dusk, and that's when snakes are out.
Objection, Your Honor. Speculation. Lacks
Your Honor,
personal knowledge.
Your Honor, may I respond?
Yes.
Your Honor, Terry is familiar with the defendant's conduct and can testify to what they observed. In addition, Edwards has lived in this area for 10 years and would have reasonable knowledge of the desert and the animals that live there.
Your Honor, may I be heard?
Yes.
The only foundation that's been laid in regards to this testimony is the fact that Miss Edwards is a desert resident. I don't believe this is sufficient foundation for her to be able to testify to the specific nature of snakes and the time of day when they're most active.
Sorry, was your objection speculation or something else?
Lacks personal knowledge, Your Honor.
Oh, okay. All right.
Your Honor, may I respond?
Yes.
Your Honor, this witness does have personal knowledge from the desert because they have been a desert resident for over 10 years and would therefore have reasonable knowledge to know what snakes and other desert creatures act like. And they need to know, they know the circumstances that this took place in, and so would therefore know that snakes are out during this time.
Is the matter submitted?
Submitted, Your Honor.
Yes, Your Honor.
On this record, the objections are sustained.
Motion to strike the testimony, Your Honor.
Motion granted.
Thank you. Nothing further.
Cross-examination?
Yes, Your Honor. Good evening, Miss Edwards.
Good evening.
You lived near both Miss Cobey and Mr. Smith, correct?
Correct.
You once hired Miss Cobey to do some gardening work for you, right?
I did hire her to do gardening, yes.
She never finished the work, did she?
She did not finish.
She ignored you when you asked her to finish the work, right?
I didn't see her around town much, no.
And she also asked you for more money for the work, correct?
Yes, she has to be paid first.
Jamie and Eric did not get along with each other, right?
That would be correct.
You were friends with Eric for 10 years, correct?
I would consider him a friend, yes.
And you knew that Eric could be rude to people in town, correct?
Everyone could be rude to people in town.
You knew that Eric specifically could be rude to people in town, correct?
Eric, including everybody, yes.
You were present at Jamie's mother's funeral, correct?
Yes, I was there.
And you saw Eric Smith there, didn't you?
Eric was there.
2 minutes.
During the argument you witnessed between Mr. Smith and Miss Cobey, you heard Mr. Smith ask, "So when are you going to move out?" to Miss Cobey, correct?
Eric did ask us, yes.
In response to this, you saw Miss Cobey's face turn red, correct?
Her face did turn red, yes.
You even heard Mr. Smith yell, "It's your fault your mom died. You should have been more responsible and taken care of her," to Miss Cobey, correct?
It was an emotional time, but yes.
Thank you, Miss Edwards. Nothing further, Your Honor.
Any redirect?
None at this time, Your Honor.
Okay,
May
thank
this
you.
witness be excused?
Yes.
In addition, Your Honor, at this time, the prosecution rests.
Thank you. So I would like the attorney scorers to let me know when they have finished scoring the examination of Terry Edwards.
Alice Luster is done.
Ray Robinson done.
Mr. Phillips is done.
Kendra Pappas done.
Thank you. I have to find my Terry Edwards score sheet. Here it is. Just a second, please. Okay, at this time, is the defense ready to call their first witness?
Yes, Your Honor, the defense would like to call Francis Yazzie to the stand.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the record, please state your name and spell your last name for the court.
Alrighty. Francis Yazzie, Yazzie.
Thank you.
May I proceed, Your Honor?
Yes, please proceed.
Good evening, Miss Yazzie.
A lovely evening indeed. Good evening.
What do you do for a living?
I used to own a restaurant known as the Blue of Galway, but now I just sell my eccentric watercolor paintings.
Do you know Jamie Cobey?
I do. Jamie's been my neighbor for about 10 years now, and she actually lives half a mile down the road from me.
Do you know Eric Smith?
Glittering geckos, I do. Gosh, Eric Smith was Jamie's landlord, and he also lived about half a mile down the road from me. Eric was not well liked by many in town, and between you and me, he even sold weed to minors.
Objection, Your Honor. Lack of foundation and improper character evidence. May I be heard?
Just one second, please. The objections are foundation and what?
And improper character evidence.
Okay, go ahead.
As to the foundation, there was no underlying testimony as of how the witness knows that that Eric had weed selling practices. This opposing counsel hasn't laid the foundation of whether minors were actually involved, if the substance being distributed was tea, whether money was involved, or whether it was actual purchase. And then as to the improper character evidence, once again on page 79 of the mock trial's rules, character evidence of the victim is admissible, but only when it's relating to a specific occasion and is intended to prove the innocence of the victim. Opposing counsel has not related this testimony, this character evidence, to any specific occasion, and therefore cannot be admissible.
Your Honor,
Did you wish to
heard.
respond?
Yes, Your Honor. As to the foundation issue, this witness would reasonably have spoken to people in town, which is where she learned the information about Mr. Smith selling weed to minors, as she used to own a restaurant, has lived in town for at least 10 years, and reasonably knows people in town. And then as to the issue with the reputation in the community, defense, this falls under reputation in the community, and the defense can bring in bad character evidence in the form of opinion for the victim.
Your Honor, may I respond?
Okay.
Once again, addressing the foundation, opposing counsel hasn't responded to the fact that Francis Yazzie has not specified or been able to testify whether the minors were actually involved, whether the substance being exchanged was tea or some other substance, or whether it was actually exchanged with money. And because these questions haven't been laid in this specific period of questioning, then it's lacking foundation. Then once again, on the improper character evidence, opposing counsel hasn't responded to that. The evidence must be relating to a specific instance of conduct that on that specific occasion would prove the innocence of the defendant.
May I be heard, Your Honor?
Yes.
Yes, as to the foundation, once again, they learned this information from talking to other people in town. She is just simply relaying what she has learned about other people in town. Not necessarily that is 100% true. She is just relaying what other people have said in town. And then once again, as to the opinion testimony, this is going to show bad character evidence in how Mr. Smith was not well liked in town, which could possibly show that there is a third party involved who could have possibly put the snake in the mailbox, since Eric was not well liked in town.
Your Honor, may I respond?
Yes.
On the foundation, opposing counsel brought up that Francis Yazzie would have reasonable knowledge from discussing with other citizens in Bernsley County, but foundation has not been laid that Francis Yazzie has had conversations with other people considering the marijuana, and therefore that the foundation for this testimony has not been laid in this questioning. And then on improper character evidence, once again, the third party culpability was not related because it doesn't show a specific instance where a specific third party would be angered, would be having a specific occasion with the victim that proves the evidence. This is extremely vague. There's an unnamed and unknown figure that the opposing counsel is describing.
Is the matter submitted?
Yes, Your Honor.
Yes, Your Honor, submitted.
The objections are sustained.
Move to strike, Your Honor.
So the part "and not well liked" and "he sold weed to minors," those statements are stricken.
May I continue, Your Honor?
Yes.
As her neighbor, do you see Ms. Cobey often?
I do. Jamie and I are actually what I consider good friends. We would hang out after work around 4 p.m. over tea.
Based on what you've observed, how would you describe Ms. Cobey's personality?
Jamie is a patient teacher. She taught me how to garden for free. And she's a loving caregiver. She was so devoted to her mom before she unfortunately passed.
Did you see Ms. Cobey on April 28th, 2021?
I did, yes. She came by around 4 p.m. after having an argument with Eric.
Did you observe anything about Ms. Cobey's demeanor?
I did. Jamie seemed to be very agitated and was very quiet.
Did she say anything about the argument?
She said that she felt hurt and that she missed her mom, but Jamie, being the sweetheart she is, said that Eric was just being Eric.
Did you see Ms. Cobey after that day?
No, I assume she was dealing with the loss of her mother, which must have been so hard on her.
Thank you, Your Honor. No further questions at this time.
Cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Good evening.
Good evening.
You would say that you've known the defendant for about 10 years, right?
I have, yes.
You would often have tea in the evenings with the defendant. Isn't that true?
That is true.
The defendant was helping you in your garden for free, correct?
She was. That's what friends do.
The two of you even talked about going into business together someday, didn't you?
We did talk about it, yes.
So it would be fair to say that you consider yourself a close friend of the defendant's, don't you?
I suppose you could say that. She's a good friend.
In fact, you've even offered to let the defendant's mother stay in your home, didn't you?
I think it's what a reasonable person would do, yes.
You also didn't like Eric Smith, did you?
That's fair to say. I had my opinion.
You thought Eric was a jerk, didn't you?
I did.
So you're not really a neutral witness here, are you, ma'am?
Objection, Your Honor. This is argumentative.
Your Honor, may I respond?
Yes.
The nature of this question is not argumentative in any way. I'm not raising my tone at the witness. I am not cutting the witness off. I'm simply asking the leading question about whether this witness was neutral, which they should be able to answer and is especially appropriate for a cross-examination.
Did you wish to respond?
Yes, Your Honor. I feel this is very argumentative, asking a witness, so you are not a neutral witness in this case. I feel this is a very argumentative question.
Okay. Is the matter submitted?
Yes,
Your Honor,
Your
may I
Honor.
respond?
I beg your pardon?
Or yes, submitted, Your Honor.
Okay. Submitted?
Yes, Your Honor.
Okay. The argument, I'm sorry, sustained.
Motion to strike the question, Your Honor.
Granted.
So, ma'am, you wouldn't want your good friend convicted, would you?
Well, I'm a person who believes in justice, so I would never want a wrong person to be convicted for anything.
Now, you were also at the defendant's house when the electricity went out, correct?
I was.
And you told the defendant that it was illegal for Eric Smith to shut off the electricity, didn't you?
I did, because it is.
But the defendant told you that the situation was being handled. Isn't that true?
She was so humble, yes.
Your Honor, thank you. No further questions at this time.
Redirect?
No, Your Honor. May this witness be excused?
Yes.
Thank you.
I will pause to allow the attorney scorers to score the examination of Francis Yazzie.
Ray Robinson, done.
Alice Luster, done.
Kendra Pappas, done.
Phillips, done.
Would the, oh, I have to write down my scores. Okay. Would the defense call their next witness?
Yes, Your Honor. At this time, the defense would like to call Dr. Tyler Clay to the stand.
Dr. Tyler Clay, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the record, please state your name and spell your last name for the court.
Dr. Tyler Clay, C-L-A-Y.
Thank you.
May I proceed, Your Honor?
Yes, you may.
Thank you. Before I start, I would like to let the court know that I will be referencing Exhibit B in this direct examination.
Okay.
Good evening, Dr. Clay.
Good evening.
What do you do for a living?
I am currently the director of the Southland Zoological Museum in California.
What are your background and qualifications as an expert witness?
I earned my BS degree in biology at the Central State University in California in 2000, and shortly after that, I earned my master's as well as my PhD degree in biology with a specialization in herpetology, also known as the study of snakes.
What experience do you have with herpetology?
Well, I have worked as a resident naturalist at various different national parks throughout my life, and growing up in the desert community myself, I've had a fair amount of experience with different types of snakes, even suffering a few snake bites.
In preparation for your testimony, what case materials did you examine?
I have reviewed the medical examiner's report about the death of Eric Smith, as well as taking a look at the Mojave rattlesnake specimen.
What can you tell us about the Mojave rattlesnake?
Mojave rattlesnakes are most active in California between the months of April to October, and during the day, they like to hide away from the sun and can be found in small, tight, dark spaces.
Is it common for people to die from a Mojave rattlesnake bite?
No, it is extremely unlikely for a person to be killed by these snakes. Victims often seek out for an antivenom or medical treatment immediately since it is widely available.
Is there any reason a victim would not seek out antivenom immediately?
Yes, victims can be lulled into thinking that their bite was not that bad. In reality, they need the antivenom immediately. This is because the symptoms of the Mojave rattlesnake venom do not manifest in the human's body until hours after they get bitten.
Dr. Clay, are there any factors that can accelerate the effects of the Mojave rattlesnake's venom?
Yes, there can. There can be both intervening and exacerbating factors.
What are these factors?
The most common one is moving around after getting bit by the snake. This causes the venom to spread throughout the body faster, making it worse. Another common factor is wasting time trying to find the snake when instead the victim should be seeking out for emergency assistance. And of course, the last one is sucking the venom out of the victim's body.
Are any of these factors present in today's case?
Yes, all three of them were.
Dr. Dunn reported that the rattlesnake that bit Mr. Smith was missing its rattle. Do you have an opinion as to how that happened?
Yes, the missing rattle here is entirely consistent with all species of rattlesnakes. They like to shed their skin about twice a year, and when doing so, they can inadvertently pull their rattles off because it is very fragile.
Referring to Exhibit B, which has been entered into evidence, do you recognize it?
Yes, I do. It is a photograph of the mailbox where the snake that bit Eric Smith was hiding in.
Dr. Clay, would it be safe for someone to dump a rattlesnake into an open mailbox?
No, dumping a rattler into an open mailbox is extremely dangerous. Even with gloves on, as Dr. Dunn has suggested, would be risky action.
Then, do you have an opinion as to how the snake may have gotten into this mailbox?
Yes, I do. Mojave rattlesnakes have a reputation of being masters into squeezing into tight spaces. So, given the size of the mailbox, Deputy Garrett's description, as well as the snake's dimensions, it is possible for the snake to either climb into the mailbox through the front door if it was open, or even through the tiny slot on top of the mailbox.
Have you seen this occurrence before, or snakes climbing into mailboxes?
Yes, I have. I have seen a couple cases before in which a snake has crawled into somebody's mailbox and attacked that person.
Thank you, Dr. Clay. No further questions at this time.
Cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Good evening.
Good evening.
Now, you're not a medical doctor, are you, sir?
No, I am a herpetologist.
So you don't practice medicine or treat patients, do you?
No, I study snakes.
But despite not being a medical doctor, you are offering opinions related to the medical condition.
Your Honor, this question is argumentative.
Your Honor, may I respond?
Yes.
This question was not argumentative. I was not raising my tone or screaming in the face of this witness. I was simply asking the question if they are offering opinions related to the medical conditions of Mr. Smith, which is in no way argumentative.
Your Honor, may I respond?
Yes.
Opposing counsel's use of the word despite suggests an argumentative question where opposing counsel is challenging my expert witness's authority as an expert witness.
Your Honor, may I respond?
Yes.
I believe the objection was argumentative, and this question is not argumentative. I am just stating that despite this witness not being a medical doctor, they are claiming that they are qualified to offer these opinions related to medical conditions.
Your Honor, may I respond?
Yes.
My expert witness has never claimed to be qualified to answer questions as opposing counsel has claimed. Thus, it is argumentative, and it also lacks foundation for them to challenge their supposed claim of qualification for these certain facts within the case.
Your Honor, may I respond?
Yes.
Opposing counsel has brought up the conditions of Mr. Smith that led to his death and the three conditions, outside conditions and factors that contributed to the death, and therefore questioning the fact that this doctor is testifying to medical conditions or the medical circumstances of Mr. Smith has foundation and is not argumentative.
Is the matter submitted?
Yes, matter submitted, Your Honor.
Yes, submitted, Your Honor.
The form of the question, despite not being a medical doctor, is impugning the testimony of this witness. And as Dr. Clay stated, he's never claimed to be a medical doctor. The question is argumentative, and the objection is sustained.
Motion to strike the question, Your Honor.
Please ask another question. The motion is granted.
Doctor, let's talk about the Mojave rattlesnake. It's the most venomous snake in North America, isn't it?
Yes, however, their bites rarely kills human beings.
The venom of the Mojave contains neurotoxins which attack nerve tissue, correct?
Objection, Your Honor. Opposing counsel is attempting to elicit an improper expert opinion from my witness.
Did you wish to? So it's a
Your Honor.
foundation objection? Yes, go ahead.
Your Honor, may I ask opposing counsel to clarify their objection?
Yes, opposing counsel is attempting to ask my expert witness questions regarding medical effects and things that have to do medically with the bite. Whereas my expert witness has qualifications in herpetology, it can testify to the general behavior and general symptoms regarding venomous bites, but cannot testify to neurotoxins and tissues regarding bites, as they are not a medical examiner and not qualified in the medical field.
Your Honor, may I respond?
Yes.
It is true that, opposing counsel, this question is talking about the venom and the poison that is contained in the venom of the Mojave rattlesnake, which this witness certainly has reasonable knowledge of because they specialize in venomous snakes. Additionally, it is stated in this witness's testimony, their own opinion in their witness statement, that the Mojave's venom contains neurotoxins, and therefore it is not calling for an improper expert opinion.
So one thing before I hear anything further on this, what is the pending question? Something about attacking nerve tissue?
Yes, Your Honor. The
What's
venom
the current
contains
question?
The venom contains neurotoxins which attack nerve tissue, correct?
Okay. So any further argument?
Yes, Your Honor, I would like to move this objection to relevance, as my expert witness is a herpetologist, and thus it is not relevant to ask them any questions regarding nerve tissue and neurotoxins.
Your Honor, may I respond?
Please.
It is relevant. The conclusions drawn by this witness are relevant because they have reasonable knowledge of the neurotoxins, therefore can make conclusions that the poison attacks nerve tissue. It's included in this witness's witness statement because they have formed this opinion already. Therefore, they have knowledge of this, and it is relevant what they believe because they are an expert in snakes, and this case has to do with a venomous snake bite.
Matter submitted, Your Honor.
I'm sorry, the matter is submitted? Okay. The matter submitted, counsel?
Yes, submitted, Your Honor.
Okay. The foundation objection is sustained. Just because something's in a witness statement doesn't mean that that particular witness has the necessary expertise to make that opinion. And also, relevance is, does this prove or disprove a material issue in dispute? And I don't see how that does. So the objections are sustained. And can you ask a different question, please?
Yes, Your Honor. Bite victims have terrible symptoms like difficulty breathing, vision loss, or cardiac arrest, can't they?
Yes, the symptoms usually manifest in the human's body hours after they get bitten by the snake.
And that's the danger of the Mojave, that the serious symptoms don't manifest until hours after the bite, correct?
Yes, however, victims usually know to seek out for anti-venom or medical treatment immediately.
But victims can be lulled into thinking that the bite was not bad, when in reality, they need antivenom immediately, right?
Yes, this is correct.
In fact, you've seen many cases where people waited too long to get help, haven't you, sir?
Yes, I have, unfortunately.
Let's talk about transporting rattlesnakes. You recommend using snake carriers like humane animal traps, don't you, sir?
Yes, I believe that anyone with common knowledge of snakes should have a snake carrier for protection.
Objection, Your Honor. The witness is being non-responsive.
Did you wish to argue the objection?
Yes, Your Honor. My expert witness has responded to the question. As he said, yes, as an expert witness, he is allowed to expand on his question and elaborate, and that is all he is doing past the answer yes, which he has already established.
Your Honor, may I respond?
Yes, because I have no idea how you think that the answer does not respond. You asked a question, you recommend using humane traps, and he said, yes, I recommend using a carrier for protection. How is that non-responsive?
Yes, Your Honor, the explanation provided by this witness after the initial response was non-responsive to the question and is running our time.
Anything further?
No, Your Honor, submitted.
The non-responsive objection is overruled.
Doctor, you also recommend long bite-resistant gloves, true?
Yes, that is correct.
And you know from the record that the defendant owned these tools, correct?
Yes, she did.
One last question, Doctor. You would agree with stipulation 21 that a rattlesnake with its rattle cut off can't be heard giving their distinctive warning sound, don't you?
Yes, that is correct.
Thank you. No further questions at this time, Your Honor.
Any redirect?
No redirect, Your Honor. May this witness please be excused?
Yes.
Thank you.
I would like to pause so that the attorney scorers can score the examination of Dr. Tyler Clay.
Alice Lister done.
Ray Robinson done.
Phillips done. Kendra Pappas done.
Great. Okay, would the defense please call their next witness?
Yes, Your Honor, the defense calls Danny Emling to the stand.
Danny Emling, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the record, please state your name and spell your last name for the court.
Danny Emling, Emling.
Thank you.
May I proceed, Your Honor?
Yes.
Good evening, Mr. Emling.
Good evening.
What do you do for a living?
Well, I run a convenience store right here in Burnsley.
Are you familiar with Jamie Cobey?
Oh yeah, I know Jamie.
How do you know her?
Well, she's my neighbor and she also xeriscaped my garden once. We've had many conversations.
Do you know Eric Smith?
Oh yes, I do.
How did you know him?
Well, he was my landlord and he was also my neighbor.
Did you pay Mr. Smith rent?
Yes, I would drop off rent checks in his mailbox once a month.
Did you have any frustrations with Mr. Smith?
Oh yes, I did.
What were they?
Well, he would shut off my utilities if I was late to pay rent, and that was always a treat. And then he would also just take forever to do simple repairs.
In the past, have you ever witnessed any interactions between Miss Cobey and Mr. Smith?
Yes, unfortunately, there have been many arguments and some fights between the two.
To your knowledge, how did Miss Cobey deal with her problems with Mr. Smith?
Well, Jamie would come and vent to me, or she would call the sheriff, and that's how she dealt with Eric most of the time.
What have you observed about Miss Cobey's actions after a conflict with Mr. Smith?
Well, Jamie could get mad, but many times after their arguments, I would see Jamie apologize to Eric.
Do you have any personal knowledge about Miss Cobey's treatment of animals?
Well, Jamie's an animal lover. She won't even hurt pests like mosquitoes.
Thank you, Your Honor. No further questions at this time.
Cross-examination?
Yes, Your Honor. May I be heard?
Yes.
Good evening.
Good evening.
The defendant was hired by you to work in your garden, correct?
Yes, you did. I did that.
You thought the garden came out beautiful, didn't you?
Yeah, it's drop dead gorgeous.
And you think the defendant is a gifted artist, right?
Yes, I do.
In contrast, you believe the victim was a terrible person, don't you?
I don't think Eric is a good person. He is a good person.
You thought Smith was a despicable person with little redeeming value, correct?
Yeah, that's what I think. I will die on that hill.
You had arguments with Mr. Smith about rent and repairs, didn't you?
I've had some arguments with Eric.
So you'd like to see the defendant prevail in this trial, wouldn't you?
Well, I mean, I would. You don't want to see anyone wrongly convicted.
Sir, as you sit here now, you're biased in favor of the defendant, aren't you?
Objection, Your Honor, argumentative.
Your Honor, may I respond?
Yes.
Your Honor, respectfully, I was not being argumentative. It was a leading question, but asking the witness if they are biased in the trial is extremely relevant, and I didn't raise my tone or ask it in an argumentative way, so I don't believe it's argumentative.
Anything else?
Yes, Your Honor. Just because they didn't raise their tone does not mean this question is not argumentative. They are asking my witness if they have bias to this person, which is clearly an argumentative question.
Your Honor, may I respond?
Is the matter? Okay, go ahead.
It is submitted.
Submitted?
Yes, Your Honor.
Argumentative is overruled?
Yes, Your Honor.
Please continue.
Would you like me to restate the question?
Yes, please.
Sir, as you sit here now, you're biased in favor of the defendant, aren't you?
I suppose you could say that.
And you're also biased against Mr. Smith. Isn't that the truth?
I guess you could say that he was not a good person.
Now, in the last few weeks before Smith's death, you witnessed multiple arguments between Smith and the defendant, correct?
Yeah, they had some of those arguments.
In one argument, you heard hushed speaking between the two, correct?
Like some of the other ones in the past weeks, yes.
Smith appeared angry, didn't he?
Yeah, Eric wasn't happy to be there.
And Smith threatened the defendant, didn't he?
He did.
You heard the defendant tell Smith that he would make the situation worse. Isn't that true?
No.
Isn't it true that you gave a statement to the police?
Say again?
You gave a statement to the police, correct?
Yes, I believe it's my witness statement.
On page 51, lines 4 and 5, you said, Eric said he would make the situation worse. Isn't that true?
Yes.
Lastly, despite your feelings about Smith, you had nothing to do with his death, did you?
I had nothing to do with Eric's death, yes.
Thank you. Nothing further.
Any redirect?
Yes, Your Honor. On cross, you were asked about a statement Eric made during a fight between Jamie and Eric. What did you see occur during this fight?
Oh, well, Jamie and Eric were having a bit of a hush conversation like they had in the past few weeks. And Eric said to Jamie that if she didn't drop what she was doing, that he would make the situation worse.
Thank you, Your Honor. No further questions. May this witness be excused?
Yes. I'm going to pause so that the attorney scorers can score the examination of Danny Emmeling.
Ray Robinson, done.
Alice Luster, done.
Kendra Pappas, done.
Phillips, done.
Okay. Okay, would the defense please call their last witness?
Yes, Your Honor. Before proceeding, the defense respectfully requests a time check for both sides.
Yes, the prosecution has 4 minutes and 4 seconds, and the defense has 6 minutes and 22 seconds.
Jamie Cobey, please turn on your camera. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the record, please state your name and spell your last name for the court.
Jamie Cobey, Cobey.
Thank you.
May I proceed?
Yes.
Good evening, Ms. Cobey.
Good evening.
As of June 3rd, 2021, where did you live?
I was a tenant. I was living at my house located at 46603 Raptor Road.
And for what period of time did you live there?
I lived there for about 10 years.
Did you live with anyone else?
Yes, I've lived with my disabled mother. I was her caretaker until she unfortunately passed away on April 22nd.
What do you do for a living?
Well, I used to work at a restaurant called the Blue Agave, but I lost my job during the pandemic. Recently, I've been stepping up my freelancing and xeriscaping work, and it's currently how I've been making a living.
Do you garden and xeriscape often?
Yes, I am an avid gardener and have been for a very long time.
What have you learned about desert animals in your time as a gardener?
Well, from personal encounters, I have learned about poisonous desert animals, including scorpions and snakes.
Do you have any tools to protect yourself from these animals?
I do. I have long-sleeve animal handling gloves, snake-proof boots. They're just among some good protection for me from poisonous animals while gardening.
Miss Cobey, are you familiar with Eric Smith?
Yes, I am. He had been my landlord for 10 years before he passed away.
Did you ever speak with Mr. Smith about his health?
Yes, I did. He told me he had high blood pressure, a kidney condition, and some heart problems.
Did he ever describe to you if he took medication for those conditions?
Well, Eric told me that he chose to use cannabis rather than his prescribed medications.
Ms. Cobey, what was the nature of your relationship with Mr. Smith?
Not good. He was a bad landlord to me and my mom, and we frequently had conflicts.
Can you describe some of the conflicts the two of you had?
Yes, among many other things, he played loud music and refused to turn it down, and even cut down some of my prize-winning succulents.
Did you ever call the police on Mr. Smith?
I called the police on Eric multiple times when he broke landlord laws or committed harmful acts.
Did Mr. Smith's actions ever harm you or your family?
Yes, they did. Eric shut off the power to my house during some of the hottest months of the year, and it actually harmed my mom.
How did that harm your mom?
Well, she relied on an oxygen tank, and it shut down when the power went out. I was out gardening in the back, so I couldn't hear her gasping, and I couldn't make it to the hospital in time. She didn't end up making it.
Do you solely blame Mr. Smith for the death of your mother?
No, I definitely don't.
Why not?
I was angry at Eric, of course, but my mom had already been very ill and was so sad to lose her, but I don't blame Eric fully for her passing.
How did your mother's death affect you?
Well, I was obviously devastated. I tried to hold it together, and I put all my time and energy into planning a funeral for her, and the day of, I got a little emotional.
What happened at the funeral?
Eric showed up uninvited and got into an argument. I was still in so much pain over my mom's death, and all he did was ask me when I was moving out. It was really cruel, so I ended up losing my temper.
What happened after the funeral?
Well, I was upset, so I went to my neighbor Francis Yaz's house.
Do you visit Miss Yazzy's house often?
Yes, Francis and I often have tea and talk into the late afternoon.
And how long did you stay at Miss Yazzy's house the day of the funeral?
Well, I left earlier because I kind of needed to be alone that day. With everything going on and what had just happened, all I wanted to do was go home and garden, keep my mind off everything and relax.
2 minutes.
Directing your attention to the morning of April 29th, what were you doing?
I was dropping off part of my rent envelope with $48 into Eric's mailbox.
Did you have anything with you besides the rent check?
I had my tool bag and a humane animal trap, but it was empty.
What do you use a humane animal trap for?
Well, while I'm gardening, I use the cage to catch animals that could potentially harm my plants, like snakes, snails, rabbits, or garter snakes. I am part of many humane societies, so I just attempt to catch them, release them back into the desert and away from my house and garden.
And Miss Cobey, you're accused of being responsible for the death of Eric Smith. Did you place the Mojave rattlesnake in his mailbox?
No, I was shocked to learn that Eric died. I had nothing to do with his death.
Thank you, Miss Cobey. Nothing further at this time, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Good evening.
Good evening.
Isn't it fair to say that you had an ongoing rent dispute with Eric Smith?
Yes, that is fair.
On occasion, Eric Smith would cut your water and electricity off, true?
Yes, that is true to my house.
In desert conditions, you needed that water for the health of your mother, right?
Yes, it was helping her oxygen tank.
And without electricity, your mother's oxygen machine, as you said, would lose power, wouldn't it?
Yes, that is true.
Then on April 22nd, 2021, Smith cut the electricity again. Isn't that so?
Yes, it was the hottest month of the year.
Without oxygen, your mother went into cardiac arrest. Isn't that so?
Yes, her health was failing.
You saw your mother struggling in her chair, didn't you?
Yes, I did, but that was after I came back. Yes.
And while you were driving her to the hospital, she died. Isn't that true?
Yes, it was 45 minutes away. I couldn't make it in time.
You were so angry at Mr. Smith, weren't you?
I was angry, yes.
You told Smith that he killed your mother, didn't you?
I do regret saying that at the funeral, but yes, I was highly emotional that day.
A neighbor even had to step between you and Smith at the funeral services, correct?
Yes, that is true.
Now, you've researched rattlesnakes, haven't you?
Yes, as a gardener, I feel it's important to have knowledge of all animals and pests.
You know that the Mojave is the most dangerous rattler, don't you?
Yes, again, as a gardener, it's important to know all potential harmful things.
So you know that spring and summer are when rattlesnakes are most active, true?
Yes, I am aware of this.
You have rattlesnake protective equipment, don't you?
Among other gardening tools, yes.
You have knee-high snake-proof boots, true?
2 minutes.
That is true.
You have long-sleeve animal handling gloves, correct?
Yes, I do.
You even have a trap that can catch snakes, right?
It's a humane animal trap. It's meant for all animals.
But right after Smith died, you sold that trap along with your tools, didn't you?
Yes, many other tools of gardening. I needed to pay off my debts.
One last matter. You knew Eric Smith had pre-existing health conditions, didn't you?
I did. Eric did tell me he had health conditions.
You knew about his health conditions the day you were at his mailbox, didn't you, ma'am?
Yes, I would hope I remembered, yes.
Thank you. Nothing further.
Any redirect?
Yes, Your Honor. Before proceeding, can I request a time check?
Yes, you have 1 minute and 4 seconds remaining.
Ms. Cobey, do you blame Eric Smith fully for the death of your mother?
As I said before,
1
I
minute.
do not. What happened to my mother was a tragedy, but I do not blame Eric fully for her passing.
And why did you tell Mr. Smith he killed your mom?
I'm sorry, what was that one more time?
Why did you tell Mr. Smith he killed your mom?
Because I was emotional that day. It was at her funeral. I deeply regretted what I said. It was said out of pure grief.
Ms. Cobey, why do you know so much about the Mojave rattlesnake and other poisonous desert animals?
30 seconds.
Because as a gardener, it's important that I inform myself of all potential harms and dangers that could befall me while I'm outside.
And why did you sell your animal trap and other gardening tools?
I was on a freelance job. I didn't have much money and I wanted to give the best send-off to my mom, so I wanted to give her the best funeral.
Thank you, Ms. Cobey. Nothing further, Your Honor. May this witness be excused?
Yes. And let me pause for the attorney scorers to score the examination of Jamie Cobey.
Alice Luster's done.
Okay, I heard Alice Luster and who else?
Ray Robinson done.
Okay.
Kendra Pappas.
sounds like I got both Kendra Pappas and Mr. Phillips done. Yes?
Yes,
Okay.
ma'am.
Thank you. So let me go ahead and enter my scores. And please remember to put your paper scores, keep notes. So at this time, I would like to invite closing argument, and I will remind the lawyers that there are no questioning by the presiding judge during the closing arguments. Would the prosecution like to present their closing argument?
Yes, Your Honor. But before I proceed, I will be referring to Exhibit B for the purposes of closing argument. May I proceed?
Yes.
Means, motive, opportunity. It's all here, Your Honor. At a minimum, the heat of passion establishes manslaughter under CalCrim 570. But truly, at the heart of this case lies first-degree murder. The elements of CalCrim 520 and 521 have clearly been met. An intentional use of a deadly rattlesnake purposefully silenced with its rattle cut off, committed with a requisite mental state of malice, and an ample period of days for deliberation, premeditation, and a time to cool off. The defendant was a landscaper, familiar with the desert and its deadly snakes. The defendant knew about the deadly Mojave and its potent venom. The defendant had trapped and released snakes, collected rattlesnake tails, and had protective gear. Snake-proof boots, long leather gloves, an animal trap, and tools. So the defendant possessed everything a person would need to trap, then release a rattler inside Smith's mailbox. Clearly, the defendant had the ability, the means to commit this cowardly crime against a defenseless 70-year-old Eric Smith. And critically, the defendant knew Smith had serious heart and kidney conditions. We also know about motive. The defendant did not like Smith. The defendant and Smith harassed each other. The police were called regularly. But in April of last year, the situation imploded. Smith temporarily shut off the utilities in response to an ongoing rent dispute. The defendant's mother lost power to her oxygen machine, and the defendant saw her struggling for breath. She died en route to the hospital, and the defendant blamed Smith. Several days later, at her funeral, Eric Smith came to pay his respects. A heated argument ensued between the two. With a clenched fist, the defendant screamed at Smith, "You killed my mother!" Later that day, retired lawyer Terry Edwards saw the defendant working in the garden during dusk, a time when snakes are known to be out looking for prey. The defendant claimed to be finishing something important, and then said, "I'm going to kill him." The following day, when Smith opened his mailbox, he was bitten by a Mojave, the most poisonous rattlesnake in North America. The undisputed facts of this case meet the very definition of a motive to kill, Your Honor. And the testimony also clearly demonstrates the opportunity the defendant had to murder Smith. Line worker Angel Russell was working on a power pole overlooking Smith's mailbox. Shortly after starting work, she saw the defendant go to Smith's mailbox. The defendant was carrying a large tool bag and an animal trap. The defendant looked down at the trap multiple times. The only other person Russell saw that day was Eric Smith. No one else. Around noon, Smith opened his mailbox and was bitten by a purposefully silenced Mojave rattlesnake, with its rattle cut off. A jar of rattles was later found by the police in the defendant's house. Only 3 fingerprints were found on the mailbox. Smith's, the defendant, and another tenant with a confirmed alibi, And let's look at the picture of the mailbox, Your Honor. According to the defense, either this 2-foot-long, 2-inch wide Houdini rattler contorted
2
itself
minutes.
through a mailbox slot only 6 inches long and 1.5 inches wide, or it climbed through the door and closed it once inside. Really? Shortly after Smith was bitten, the defendant sold the animal trap and tools, disposing of crucial evidence that could never be tested. Powerful evidence of consciousness of guilt. Finally, both experts agreed that the highly toxic venom of the Mojave contains paralyzing neurotoxins. Smith may have felt all right for a while, but later, the paralyzing agents would go to work. He didn't stand a chance. Revenge, it said, is a dish best served cold, when someone least expects it. And that is exactly what the defendant did with a cold-blooded rattler
1 minute.
purposefully silenced. Revenge, desert style. Calculated, planned, exacting. This is first-degree murder, Your Honor. Thank you.
Thank you. Would the defense like to present their closing argument?
Yes, Your Honor. May I proceed?
Yes.
Eric Smith's unfortunate death was not the killing of one human by another. It was a tragic but accidental death at the hands of Mother Nature. Jamie Cobey did not place the rattlesnake in Mr. Smith's mailbox. On the morning of April 29th, Jamie Cobey was seen by Mr. Smith's mailbox while she was dropping off part of her rent. The prosecution alleges that Jamie placed a rattlesnake inside Mr. Smith's mailbox, a claim based largely on the observations of Angel Russell. But you heard Angel Russell testify today that he has no recollection of seeing something inside the cage or seeing Jamie open or close the mailbox door. Herpetologist Dr. Clay further explained that it would have been an extremely risky action for Jamie to dump a live rattlesnake into the mailbox. The presence of the snake can instead be explained by natural occurrences. Dr. Clay testified that a snake's rattle can come off naturally in the wild and that snakes are known to squeeze into tight spaces like the mailbox. The snake could have gone into the mailbox to seek shade in a dark space. The prosecution also alleges that Jamie placed the snake in Mr. Smith's mailbox with an intent to kill, knowing that a snake bite would cause Mr. Smith's death. But Jamie could not have planned nor predicted the series of events that ensued after the bite and ultimately caused Eric Smith's death. Mr. Smith already suffered from several pre-existing conditions for which he did not take his prescribed medications. These untreated conditions were exacerbated by the rattlesnake venom. Additionally, Mr. Smith refused any medical help after being bitten by the snake, instead insisting that he would tough it out. Dr. Clay testified today that it is extremely unlikely that Mr. Smith would have died if he had received medical assistance. Death by rattlesnake is very uncommon, especially in desert communities, because victims know to seek out anti-venom immediately. You even heard from Deputy Garrett that Mr. Smith was well known in the community as an expert in desert living. Why would Jamie choose to place a snake in Mr. Smith's mailbox when she was well aware that the bite could be easily treated with anti-venom? On May 2nd, Deputy Garrett went to Jamie's house to conduct her investigation. If Jamie had consciousness of guilt, she wouldn't have let the deputy unattended to search her home while she was outside gardening. She wouldn't have left her snake-proof boots and animal handling gloves in plain view in the garage, and she wouldn't have openly admitted to having sold her snake, her animal trap, and other gardening tools. The prosecution has failed to prove beyond a reasonable doubt that Jamie Cobey removed a snake's rattle and placed it in the mailbox. But even if the court disagrees, this was not a premeditated and deliberate murder. Mr. Smith shut off power to Jamie's house, which contributed to the death of her mother. Following this, Mr. Smith showed up uninvited to Jamie's mother's funeral, which obviously upset her. Mr. Smith even told Jamie, a daughter mourning the death of her mother, that it's your fault your mom died. Anything Jamie did following the funeral would have been in response to the substantial provocation by Mr. Smith and did not constitute premeditation or deliberation. Your Honor, Jamie Cobey is not a murderer. She's a gardener. She had the necessary tools to protect herself from poisonous animals because gardening is her passion and her livelihood. The prosecution claims, all by way of circumstantial evidence, that Jamie planned and executed an extremely complex murder plot. They allege that Jamie placed a live rattlesnake in Mr. Smith's mailbox in broad daylight without an eyewitness ever seeing the snake. They allege that Jamie knew exactly what pre-existing conditions Mr. Smith had and that she knew the Mojave rattlesnake's venom would exacerbate these specific conditions. They allege that Jamie knew Mr. Smith would refuse anti-venom despite the fact that all desert residents know a rattlesnake bite must be treated immediately with anti-venom. The prosecution's claims are unreasonable, and there is a far more compelling interpretation of the facts. That the snake lost its rattle naturally in the wild and climbed into the mailbox to seek shade. Dr. Clay even explained that he has seen prior cases of snakes climbing into mailboxes. This was not an elaborate murder plot. It was an accidental death at the hands of Mother Nature. The law makes it clear. Even when there are two reasonable interpretations of circumstantial evidence, one that points to innocence and one that points to guilt, the court must adopt the interpretation that points to the defendant's innocence. The prosecution has failed in proving guilt beyond a reasonable doubt, and the defense respectfully requests a verdict of not guilty. Thank you.
Thank you. Would the prosecution like to present its rebuttal?
Yes, Your Honor. May I proceed?
Yes.
It wasn't an act of nature that killed Eric Smith. It was the defendant's cold and calculated crime. Your Honor, the defendant hated Smith, to say the least. But it wasn't an act of nature that Danny Emling got impeached on the stand. It also wasn't an act of nature that forced Danny Emling to admit to being biased. Clearly, the credibility of the opposing counsel's argument is in question. Finally, the operative word is reasonable doubt, not any doubt. And as this court knows, when there are two interpretations of the evidence, one pointing to innocence and the other to guilt, the court must adopt the reasonable one, even if it leads to guilt. And that's what we have here. Guilt.
And would the defense, thank you, would the defense like to present its rebuttal argument?
Your Honor, Jamie Cobey did not place the rattlesnake in Eric Smith's mailbox. The prosecution alleges this was an act of revenge, desert style, failing to acknowledge that all desert residents know exactly how to treat a rattlesnake bite, a fact that Ms. Cobey was well aware of. The prosecution relies largely on the testimony of Dr. Dunn to prove their case and argue that the rattlesnake was placed by Ms. Cobey. But, Your Honor, this witness attempted to testify to the behavior of rattlesnakes, testimony that was stricken by the court as an improper
30 seconds.
We must instead look to the testimony of herpetologist Dr. Clay, who testified rattlesnakes are known to squeeze into tight spaces like the mailbox. Additionally, Deputy Sheriff Tony Garrett was impeached on the stand today for failing to testify that Ms. Cobey left her gardening tools in plain view in the garage, a fact that clearly demonstrates that Ms. Cobey did not have a consciousness of guilt. Seeing as there are two contrary reasonable interpretations of the circumstantial evidence in this case, the prosecution has failed in proving guilt beyond a reasonable doubt.
Thank you. So first, I'm going to give the students 1 minute to consult with their teachers and attorney coaches regarding trial irregularities. And also I would like the attorney scorers to finish all their scores, everything on the ballot. Remember to put 0 in the penalty box because we're not doing that. And tell me when they have finished completing their entire ballots.
Ray Robinson, done.
Alice Luster, done.
Phillips, done.
Ms. Pappas, I didn't hear from you.
Sorry for that. I'm done too. Thanks.
Okay, great. Are there any trial irregularities to note from the prosecution?
I believe that the both counsels get 30 seconds or a minute to confer with their coach before making this decision. Is that correct?
Yeah, I started the time, but if I could do another minute if you need, because I started the time. But
my apologies, Your Honor. The people find no.
So I could start a minute. We'll do a minute now. I have to complete my ballot anyway. Okay, a minute has passed. Are there any rule violations to note from the prosecution?
No, Your Honor. The people find no trial irregularities.
How about from the defense?
No trial irregularities from the defense, Your Honor.
Okay, so all the scores have been submitted, and we're not doing the judge's choice or MVPs in this round, and I will announce the verdict. As the fact finder and the jury in this case, because this is a court trial, the court finds the defendant, Jamie Cobey, not guilty. So at this time, and I just would like to remind everyone that the verdict has nothing to do with who wins. I don't think anybody knows who won because, we all submitted different scores and I didn't count up my scores, except to say that all the performances were amazing. I think at this time we're going to go into a separate room and end the live stream. And I will invite, once we're over there, I'll invite the attorney scores to give their comments.